List. I want to place one thing, madam. Criminal appeal number 259 of 1996. Although I was appearing in that case for the judgment, my name has not been reflected. Kind of a glance. I was appearing for appellant number 2. My name has not been reflected. I came to know from the net copy. Gauri Shankar Pani for appellant number 2.
All right. Mentioning the causality in the judgment will be reflected, changed. It's altered as follows, and then put on the causality and will represent it. But is it the judgment we read? Mr. Katke is here? No. All right. Don't we get yes. In the judgment? You never find the name. To comment. Not immediately, whenever. Okay. It's okay. Okay.
I call the list. Supplemental list, old matter, item number 1.
None of this.
My lord, item number 1. May I please? Item number 1. This is a, my lords, here, my lords, fraud was played by the state government. Your lordship will see in this matter, this is a writ appeal. Only one clarification can be done, that the judgment which has been passed by the court below under Annex 6 by this court, whether it is a judgment in rem or judgment in personam. 1.
Sir, for 16 years, you did not get this matter listed, sir.
That is not my responsibilities, sir.
I see. I see.
The matter has come up after 16 years. Your lordship is telling. Is it our responsibility to file a memo and get this matter listed? If the judiciary is, and second, the noting is that this has been shredded into pieces. The documents have been shredded into pieces. The judgment which we are challenging, that judgment has been shredded into pieces.
Mr. Ratha, I'm sure people listening to you are going to be aghast listening to you, particularly your client. Forget about any lawyers and judges. Your client is going to be aghast listening to you. This is the only comment we can make. Can you tell us what the matter is about?
My lord.
Yes.
My lord, first of all, my lord, the judgment which is under challenge, that is under Annex 6.
Yes.
The noting is that limitation is not necessary because we were not made parties in the judgment.
You tell us what the case is about, sir.
My lord, our case is that we were appointed as Swechasevi Shiksha Sahayaks. And subsequently, my lords, government came up with a circular which was not intimated to anybody. A judgment was passed behind our back, wherein we were not made parties, that is Annexure 6, which is impugned. That we were appointed as Swechasevi Shiksha Sahayaks. We continued on contractual basis for 2 years. In between, my lords, the select list was valid for 1 year. The number of posts which was advertised pursuant was 15,682 posts. And out of that select list, they went on giving appointment, for which a writ was filed before the court by some persons who were aggrieved. In that, my lord, the state government did not mention that the opposite parties were affected and they were already appointed. None of them were made parties. No notice was given to them. And in that writ petition, that circular, they said that this circular was against the principles of selection because 150% of post was to be filled up as per the advertisement, but the state government went beyond the record and went on filling up the posts by creating number of vacancies from the select list, and they went on appointing. That is how the appointment order was, the circular was quashed. But my only predicament is that this should be made prospective, not retrospective. And it should be a judgment in personam, not in judgment in rem. Because my rights should be affected, because here it is a consideration that we have been continuing, subsequently filed writ, and that was we were continuing. And there is a scheme which has again floated after the Swechasevi Shiksha Sahayaka scheme was abolished, that they will become primary school teachers if they're for more than 7 years. So therefore, that seniority should be maintained, and accordingly, we could have been granted relief. So that is the only cause of action, nothing else, my lords, which survives in this petition. Because that judgment which has come up, the judgment has been passed under Annexure 6.
What is the delay in your filing the appeal, sir?
My lord, there is no delay, I will say, because I have alleged two things. One is that your lordship is aware of Section 17 of the Limitation Act, that fraud has been alleged against the state government, wherein, my lords, the limitation will not come into play. Second, the writ petition, we were not made parties. We only came to know subsequently. So since we were not made
What is the explanation you have given? What is the application for condonation of delay?
My lords, this condonation of delay was pointed out by the stamp reporting, because we didn't have any, that time, your lordship will see, I have given under paragraph, your lordship may kindly see my ground, which I have taken, page 5, Roman 3. For the fraud played by the state government by not bringing it to the notice of this honorable court, that the collector in a single education district has already given.
Where are you reading?
This circular.
Where are you reading?
Page 5, my lords. Ground number 3. 2 and 3. The petitioners being already appointed, this honorable court may be pleased to direct in the writ appeal that the judgment of this honorable court passed in WPC 11748 of 2003 should be confined to the facts and circumstances of that case and should not be made applicable to the petitioners who were not parties to the said judgment. For the fraud played by the state government by not bringing it to the notice of this honorable court, that the collector in a single education district had already given effect to this circular and appointed persons in the year 2003 before pronouncement of the judgment. The petitioners cannot be victimized because of the fraud played by the state government by not bringing it to the notice of the honorable court that the circular had been given effect to and the petitioners were already appointed. And in case this circular is such, direction of this honorable court may be only confined to such candidates who had been appointed pursuant to such circular on the date of judgment. So that is my only limited grievance.
When did you file this writ appeal?
This writ appeal, my lords, I have filed it in 2006. The exact date, my lords. Exact date, I cannot say. This judgment was pronounced in the year 2000.
Kindly turn to page 15, sir.
My lord.
What is the date that you put there?
That about the circular dated under Annexure 2, 26.
What is the date, sir? What is the date in your paper book? Do you have the paper book? There is a certain date given there.
9/2006.
So you have not actually, what you have filed here, you do not have a copy. For your information, we can tell you, you filed it on 18th September 2006.
My lord.
What is the date of the impugned judgment?
The impugned judgment, my lord, date is 2004. And
Do you have that date or you don't have even that date?
29/4/2004.
So what according to you is the delay, sir?
My lord, according to me, the delay portion is explained in view of the fact that the judgment.
You're orally explaining now.
My lord, overall, I have to explain because I have.
Orally. You're orally explaining the delay.
My lords, I can't improve upon it.
You see, the full order. You see, this writ appeal was filed on 18 September 2006. And a report of the stamp reporter mentions that it is delayed by 843 days. Paragraph, when asked how this writ appeal was not even listed once in the last 16 years, counsel of the appellant replied that it is not his duty. It is not his duty or concern to get the appeal listed. And it is entirely for the court. It's a lookout of the court, whether the appeal is listed or not. Full stop. It must be mentioned here that this appeal was listed on the direction of the court and not upon mentioning of the counsel for the appellant. Be that as may, the writ appeal is not even accompanied by an application for condonation of delay. So when asked about this, counsel for the appellant again seeks to give only an oral response, referring to Roman para 3.
My lord, may I submit, my lord? I don't
Para
want to
2,
please.
Roman para
My lord,
3,
my lord, can
alleging
I-
some fraud played by the state government. A perusal of that paragraph does not reveal the explanation for the extraordinary delay of 843 days in filing the present appeal. To say the least, with there being no explanation for such extraordinary delay, the court is not inclined to condone it. The writ appeal is accordingly dismissed.
my career would be
Item number 2.
That's item 2, 3, and 4 are appeals by the state. There's a delay of say more than 2 years.
Unexplained delay of more than 2 years. The application for delays, not even steps for limitation have been taken in the last 11 years. The appeal is dismissed.
Item number 3.
2, 3, 4 are Millard's.
All the same.
All
All right.
right. Item number 5.
May I please, your lordship? My lord, last appeal, my lord, last night the brief has been transferred to.
That's all right, sir. What the matter is about, you tell us.
Oh,
Even we got this brief last night only,
my lord,
but we are ready with the matter.
furthermore, the counter has to be filed by my senior law and government
It's
counsel.
only 10 years old, sir, this writ appeal.
I have
It should not
not.
become older than this.
There are so many factual aspects for that. Last night I could not prepare. 2 days, my lord.
We'll both jointly read it, sir. We'll both jointly read it. All right.
My lord, I have no power also. Today I will file power.
It's all right. Tell us what the matter is about. What's the delay?
My lord, I have not through the record hall.
We'll help you, sir. We'll help you. We are here to help you. Not requisites filed. There are 2 appeals, is it? 223. We can pass it over, you read it and come back. All right. We are not adjourning it. We will pass, sir, we will pass it over. Kindly read the paper book. We'll call it after passover. All right. Next matter.
Supplementary list, item number 6.
Item number 6, your lordships, I am appearing to BC. Pardon to. But this is this writ appeal was directed against an interim order. In the meantime, the main writ application
All
has been
right.
disposed
Counsel,
of.
the appellant states that the writ appeal has become infractuous, disposed of as such. Yes. Both matters.
And the WA number says.
Yes, sir.
67
Fine,
attached
fine.
is-
All right, sir. All right.
Item number 7.
Well, item 7, 6 number of cases infractuous.
Infractuous.
I provide the numbers, 6 numbers of cases.
Then what about the remaining?
Other cases are there.
I am for the respondent, my lord.
All right.
My lord, I am for the respondent in all these cases.
All right, sir.
I am also in 2 cases respondent for the Kendra Vidal Sadan.
All right.
My lord, there is a small prayer, my lord. My lord, by interim order, their payment of the fees has been stayed. Let them not pay it.
Area.
They have to pay.
May I please, madam? I am the
By this method, they can.
33334. This is the unnatural fees hike was challenged before this honorable court in year 2009, madam. And this court was passed a rigid order that was the fee structure, and subsequently in second case, another court was passed that the case the fee structure was enhanced, was correct. Both the contractory to single bench.
I have not understood anything that you're saying, sir. Sorry.
Yes, ma'am.
My brain is a bit dull, so I'm not able to understand.
Yes, ma'am.
So kindly
I explain that.
Please be kind to me, sir.
Yes, ma'am.
Kindly tell me in a manner I can understand what you're saying.
In year 2009, the Kendriya Vidya Sangathan was hike the fees.
May I clarify, Malo? Actually, fee hike in Kendriya Vidya Sangathan was the subject matter of consideration. That it was allowed. Against that, he has filed one writ appeal. Now, those
writ petition.
Writ petition. Now the students have gone long back because this is a matter of 2009.
So they are trying to tell us it is infractuous.
Yes.
All right.
But they claim that area that the students are already passed out from the 2009 and the last 14 years. The area will not be
cannot be paid now, sir. Obviously. You see, due to passage of time, subject matter of the present writ appeals has been rendered infractuous. It is disposed of as these writ appeals are disposed of as.
Union of India appearance may be noted because all
right. All right. All right.
Okay. Supplemental list item number 9.
Those 6 matters are included in these 6. Huh?
8 is also same.
7 and 8
both are same.
Both are same. Achha. That's well. All right. 7 and 8.
Clarification may be that they cannot demand the areas from the.
We'll leave it at that, sir. Right.
Item number 9. Item number 9.
None appears dismissed.
Item number 10.
Item 10, Lordship, matter become infractuous.
Yeah, it's infractuous dismissed.
Item number 11.
None appears dismissed.
Item number 12.
I'm in VC matter.
Yes, please.
Item 12, madam. Here the petitioner challenges the impugning the order at Annex 5 matter. That is running to starts from 196. Here main point, my lord, the employee being the petitioner under the council, my lord, that is Council of Higher Secondary Education Odisha, while placing under in suspension, the Odisha government CC rules, that is classification control appeal rule, is not applicable to the employee, which is main point that was not taken concession by the court below is that judgment that Annex 5. I am placing current to place running page 205, the para 12 of the judgment matter. Contention raised provisions OCS CCR 62 is not applicable to the petitioner. Therefore, the order of suspension passed by authority cannot sustain. In para 2 of the writ petition, the petition has pleaded it is a fact that the suspension of funds of 212 clause 1 A of CCR rules is applicable. All the government rules circulars are applicable to funds. So, false. The facts pleaded in para 2 of the writ petition has been disowned in the rejoinder filed by the petitioner, stating that para rule clause so is applicable to the CSU Odisha per contra. SPG General Lord Council for the Council strenuously urged that by virtue of resolution passed in 1991, Council has adopted government rules, regulation for employees CSU Odisha Swans rules 62, being applicable to government employees is also applicable to the employees CSU Odisha. Hence, action taken by the authority cannot be found fault with the same.
Mr. Mohapatra,
My lord.
You're in the writ appeal challenging an order of the single judge, correct?
My lord.
Which is that order, sir, and what is wrong with that order?
My humble submission, Lordship, that placing the suspension under Rule 12, that is mean.
Sir, I'm repeating the question. If you do not mind, sir, can I repeat the question?
Well.
Which is the order of the single judge that you are challenging? That is question number 1, sir. And question number 2, what is wrong with that order?
That the finding of the honorable
Sir,
court.
I'm repeating for the 3rd time, sir.
My lord.
Which is the order of the single judge that you are challenging? Which page of the paper book is that? The second question is, please tell us what is wrong with that order. I have repeated 3 times, sir. I will not repeat hereafter.
Well, the para 12 and 13 of the judgment, my lord.
Which judgment? Which order is on the challenge side? Order dated?
The date was 6 August 2015, madam.
And which page?
Page 207, madam. Answer 5.
Sir, the judgment starts at 197.
997, right, madam?
That's from 195.
195. No, 195 in our paper book is some Supreme Court order.
Okay. My appeal, that is 190. It starts from page 194. Then the operative 196. Judgment started from 195.
Anyway, in our paper book, 195 is the Supreme Court orders. I don't know which paper book he has now. We don't know that.
You also right, man. Supreme Court order 195, thereafter 196, answer 5 stats. That is answer 5, and 7, answer 198. Thereafter, answer 1, that is 199, 1 to 2000.
This is only a suspension order, is it?
Yes, ma'am. He has been reinstated. The last
already reinstated.
Yes, ma'am. Lords may see the last portion of that order.
What suspension?
Lords can read it from paragraph 14.
The matter has been in my lord. In the meantime, he retired on 31st January.
Oh, he already retired. 31st January of
22. And he has received all his benefits.
I see.
Benefit.
That's not fact. Due to decision being not taken regarding the period of suspension, is by virtue of operation law, is suspension order is void by being not followed the proper rule. That the pension rule as adopted by the council, my lord, they followed due procedure and approved by government as per Rule 30 of their act, my lord. The may permit to place the grounds, my lord, I have stated in para 6 of the writ appeal, my lord. I have stated all the grounds. They have not, even the council has not filed any counter till date, my lord, as let's. So, being not in aberrament, as lordship knows, the aberrament, specific aberrament background being stated in the petition being not specifically controverted as the Supreme Court judgment should be admitted. They have not a single counter filed till date, even from the date of filing of the writ appeal, my lord.
Still not answered. He has not answered the question. The challenge in the present writ appeal is to a judgment dated 6th August 2015, passed by the learned single judge, dismissing the appellants. Writ petition civil 1982 of 2014. Stop. It must be noted at the outset that the impugned judgment was common to the above writ petition as well as 4 other writ petitions seeking similar relief. Paragraph. In all the writ petitions, challenge was to in the writ petition filed with the present appellant, the challenge was raised to a suspension order dated 22nd September 2014 on the ground that the OCS bracket CCA bracket rules 1962 was not applicable. Full stop. Challenge was also raised to a charge memo dated 18th December 2014, which apparently was served on the appellant on 29 December 2014, which was more than 3 months from the date of suspension. Full stop. Background facts are that there are 7 now. Writ appeal or writ appeal?
Writ appeal.
No, there are 7 says. Which para 6? Writ appeal or oh, again in the grounds there is 1, 2, 3. There are 6. The appellant was an employee of the Council for Higher Secondary Education, bracket CHSC, Odisha. Stop. He was at the relevant time functioning as the president of the Employees Association of CHSC, Odisha, and had placed before the CHSC 7-point demand charter. Full stop. area, it appears that the members of the Employees Association, through the appellant, went on a strike, paralyzing the entire public delivery system by mass absenting from official duties. Full stop. The explanation offered to the letters issued to them were found unsatisfactory. Full stop. Due to the continued disruptive behavior, the appellant and other employees were placed under suspension. And this was challenged initially by way of Writ Petition Civil 21418 of 2014, which is disposed of by the learned single judge on 10th December 2014, directing the authorities to dispose of the representations filed by the petitioner within 2 months. Stop. After the representations were rejected, a second round of writ petitions was filed, including Writ Petition Civil 19282 of 2014, in which the common impugned judgment dated 6th August 2015 has been passed, dismissing the writ petitions. Full stop. The learned single judge has elaborately dealt with each of the contentions raised by the appellant, challenging the order of suspension. The learned single judge has observed that placing an employee under suspension in contemplation of disciplinary proceedings cannot be said to be legal if it had been passed by an appellate authority who is in any event competent to issue it under the rules in question. Full stop. As regards the change of headquarters for reporting, the learned single judge noted that an interim order had been passed on 20th October 2014, allowing the writ petitioners to continue in their respective places of posting without changing their headquarters. Full stop. Therefore, on that ground also, there was no merit in the contention of the writ petitioners. Full stop. As regards the merits of the disciplinary inquiry, it was observed that it could be examined at the appropriate stage. Paragraph. During the pendency of the present writ appeal, the inquiries have all been concluded. The present appellant was reinstated, was allowed to continue in service. He superannuated in January 2022, receiving all the retirement benefits, as informed by learned counsel appearing CHSE
Yes.
All right. Paragraph. Having examined the impugned order of the learned single judge, the court finds no error having been committed in rejecting the prayers of the present appellant. The court is therefore not inclined to interfere. The writ appeal is dismissed.
Supplementary list item number 13. Item 13.
None appears.
Item number 14.
May I please, my lords. Well, the 60 days delay, my lord, notice was issued by mother side, and I filed the miss case, explained the delay, my lord. For merit is concerned, my lord, the annexure 1, impugned order of learned single judge, my lord, dated 15th of May 2015 is under telling, my lord. My lord, this point involved, my lord, whether admission by a party in the court proceeding, whether it is binding effect in subsequent proceeding, my lord, that's the point of learned court, my lord, held that since it was not adjudicated, therefore not binding effect, though I have cited a Supreme Court judgment, my lord, directly on the point, that was not discussed, my lord, it was ultimately, my lord, the petition was dismissed. My lord, the facts is like this, my lord, this I was appointed by ITCOL, Industrial Development Corporation Limited, my lord. Initially, I had the interview, I was appointed by ITCOL, my lord, I continued in ITCOL, but ITCOL are 10 subsidiaries, my lord. Aska spinning mill, Barampur spinning mill, and Sonpur spinning mill, and these 3 spinning mill together, ABS spinning mill limited were there, with effect from 1/4/1990. Well, that merger spinning mill became one spinning mill, and it continued. Well, thereafter also till August 1991, I was allowed to continue with ITCOL, my lord, Industrial Development Corporation Limited, my lord, as employee. And then when I was shifted to again ABSL, spinning mill, then I raised objection and filed a representation. My lord, my representation was rejected with a warning that why you are representing before the ITCOL authorities, and my representation ultimately rejected, my lord, by in my lord annexure 8, page 37, by the my lord ABS Spinning Mill Limited, saying that you are not the employees of the ITCOL, you are employees of the ABS Spinning Mill. That was under challenge, my lord, in this petition. My lord, my specific my lord prayer before lordship is, if your lordship kindly come to page 39 and 41 of the writ appeal, I have enclosed 2 affidavits, stands 2 affidavits in a previous writ proceeding, where my lord both ABS Spinning Mill and ITCOL, they have admitted that I am an employee of the ITCOL. They have admitted in clear terms, my lord, I am the employee of the my lord ITCOL. My lord, but that fact has not been taken note into account. But my lord, single judge has rejected my claim, saying that this had not been adjudicated. My lord, what happened in those cases, my lord? Those cases, that spinning mill union filed the case to get the my lord, financial benefit at par with ITCOL employees. My lord, that was subsequently withdrawn. But I am not on that. I am not a single by said, my lord, I am since I was the one of the member of the union, so therefore that also covered, because the union filed that case. But I am not the member of that union, because I am not in their role also. I am the employee of the ITCOL, my lord, pursuant to advertisement, and my appointment order, if you lordship kindly see the appointment order, my lord, I am placing the appointment order, annexure 3, page 30. Page 30, my lord, lordship kindly, my lord, page 30, it goes very root to the matter, my lord. Page 30 is the appointment order in the writ appeal, my lord. Annexure 3. My lord, this is what my permitted place, my lord. Please refer, this is issued by ITCOL, my lord. Please refer to your interview, which interview you had with the OS on 14/11/1998. Pleasure to inform you that you have been selected for the appointment senior supervisor civil in our Aska Spinning Mill Limited on the following terms and conditions. My lord, the salary, you will be given basic pay of rupees 482 such and such with usually as admissible by the corporation from time to time. My lord, pay structure is applicable as per corporations. Your headquarters will be fixed at Aska. Well, that point of in 83, the Aska was a subsidiary of unit of the ITCOL. Therefore, I was placed in Aska. If you come to, my lord, para 7 of the terms and conditions, that says, my lord, I will abide all the existing rules, departmental order of the corporation, and those that will be framed in future. That is there. Even your lordship, para 10 of the condition, my lord, infringement of any of the rules of the corporation That means in
Sir, can I ask you a question?
Yes, ma'am.
What is your age now, sir?
My lord, I have only question of financial ability, my lord. In October 2020, proposed I have retired. Only thing is, my lord, financial, because this has been wind up procedure, ABS spinning is going on.
It's completely infractuous, sir.
No, my lord. It's
Yes,
because
totally infractious.
If a lord
your prayer in the writ petition, well, you should be absorbed and treated as employee of IDCOL.
Yes.
You have now retired, sir. You have superannuated. The relief can't be granted, sir.
No, retired, my lord. What happened? In the meantime, what happened, my lord, in 2010, it was closed. BS was closed down. It was because liquidation proceeding is going on, my lord. It was closed down. I have been neither in ABS nor in IDCOL because of the and continuing this litigation. Because, my lord, I have a judgment, my lord. You will have to kindly the same judgment, which is, my lord. Lord, so kindly see, my lord, what is the evidence below admission, my lord. Therefore, my lord, I pray. So, Lord, so kindly come to only, my lord, this one point is a page 39. So, Lord, so kindly comes to page 39, Annex 9. Lord, my lord, para 26. So, Lord, so kindly come to judgment para 26. Para 26, my lord. From a conspectus of these cases cited at the bar,
what is this to do with? What are you citing, sir? Some rent control, eviction matter?
Principle of admission, what my contention before Lordship, but the admission in pleadings.
So this is rent control matter.
No, but the principle of admission. That if my lord, therefore I am to your lordship count on page 39. Your lordship kindly 2 pages I will place. Therefore, your lordship page 39, Annex 9. In the chapter. Well, page 39. Yes. Well, para 5, the counter affidavit filed by, well, this is the counter affidavit by that spinning mill. Malad, the opposite part number 3, Malad. They said that the workmen of the said mill are appointed by the unit head of the mill. That means Malad spinning mill. And its label and salary wages are determined by that the reliance by the petitioner for appointment letter upon Sibasakha Mukhopadhyay, which are the petitioner, is absolutely misconceived and has been cited to create confusion. As the said person belonged to supervisory category 1 was recruited by the corporate office of the corporation at initial stage of the establishment of the mill, and such appointment doesn't exceed 3 in number. It is pertinent to mention that here that all other workmen have been appointed by open jury. But a total 3 person was appointed in spinning mill by the IDCOL, and I am one of them. All other persons were recruited. This is the affidavit by the Lord Spinning, and your lordship IDCOL affidavit next page, para Annex 10. IDCOL also filed takes the stand, my lord, that at page 41, it is not a fact that appointment letter of various category of employees were similar to that of Sibasakha Mukhopadhyay. Certain supervisory workmen were recruited by the corporate of the corporation at initial stage of establishment of Aska spinning mill, numbering 3 only, who were issued appointment letters from corporate office for Aska spinning mill, and Sibasakha Mukhopadhyay is one of them. Other appointment letters were issued by the Aska spinning mill. Suppose when the admission by both the organization is that I am the employee of the of the IDCOL, my lord. Therefore, the IDCOL is the competent authority. I should have been observed in IDCOL even after, my lord, this now the winding up of the ABS spinning mill, my lord, from 2010 to 2020, the prospective date of superannuation. Therefore, my lord, my submission before the Lord single that was there, my lord, I should be continue as the employee of the IDCOL, which was, my lord, refused.
The challenge in the writ appeal is to a judgment dated 15th May 2015, passed by the Lord Single Judge, dismissing OJC number 8831 of 1998, filed by the present 1996, filed by the present appellant, seeking a direction to Industrial Development Corporation Limited, bracket IDCOL, bracket respond by 1 bracket, to take him back from ABS Space Limited, bracket ABS, bracket to IDCOL, and treat his period of service in ABS as being on deputation. Stop. He also prayed for quashing with a letter dated 24th July 1996. issued by it called rejecting his representation, pointing out that he continued to be an employee of ABS, a subsidiary company of ITCOL, with effect from 1st April 1990. Paragraph. The admitted facts are that although the appellant was initially appointed by ITCOL, initially engaged by ITCOL by a letter dated 3rd December 1983 as senior supervisor (civil), and joined the Aska spinning mill on 15th December 1983. He was subsequently transferred to the Bharipada spinning mill and thereafter to ECBDL Paradeep on deputation. Full stop. Paragraph. On 6th February 1990, a memorandum of understanding was signed between ITCOL, Sonpur spinning mill, bring the operation of 3 industrial undertakings, that is, Aska spinning mill, Bharipada spinning, and Sonpur spinning mill, under a single corporate entity. Full stop. A new company called ABS Spinning Mill Orissa Limited, ABS, was registered under the Companies Act 1956 with effect from 20th March 1990. Full stop. ITCOL concerning the above merger with effect from 1st April 1990. Full stop. After the formation of ABS with effect from 1st April 1990, the services of the appellant were placed with ABS. Full stop. He kept getting his promotes there. And despite his representations that he should be taken back to ITCOL, that was rejected way back on 24th July 1996. So thereafter, he is promoted as deputy manager, which post he joined under protest. Full stop. The learned single judge, paragraph. You say the learned single judge noted that after the formation of ABS with effect from 1st April 1990, there was a severance from the earlier employment with ITCOL. Full stop. Although it was a subsidiary of ITCOL, ABS was a separate entity. In fact, a reference is made to writ petition OJC number 1599 of 1990, in which employees of ABS, including the present appellant, had been asking for same scale of pay made available to employees of ITCOL. Full stop. The said petition was dismissed by this court, and that order became final. With ABS being a new juristic person with its own standing, the petitioner, the appellant could not possibly claim continuation in ITCOL. Paragraph. During the pendency of the present appeal, the appellant has superannuated, and the question of granting him relief of being reinstated in ITCOL, transferred to ITCOL, and being treated as an employee of ITCOL at this stage does not arise at all. paragraph. In any event, apart from the fact that the delay of 100 days in filing the present appeal has not been properly explained, even on merits, the court finds no grounds to interfere with the impugned order of the single judge. Full stop. Where the petitioner's services have been placed with ABS, which was a separate entity, that was April 1990. He could not have claimed continuation with the erstwhile entity, with the his erstwhile employer, ITCOL. Full stop. Consequently, the court dismisses the appeal both on the grounds of delay as well as merits.
Supplementary list item number 15. Item 15.
None appears dismissed.
Item 16.
What about the second connected case?
That is simple.
1 minute. With pending. Why was this called for?
My lord,
Oh. And why is all this come before the division bench? Oh, what it appeal is challenging which order?
Yes.
8/10/2015. It's on 28th November.
Supplementary list item 16.
May I please, Your Lordship? Your Lordship, application challenging the judgment date 22/9/2015 on the grounds that when the application, the impugned writ application was filed by the petitioner therein, she was 52 years of age, 51 years of age at that time. And the Anganwadi worker, the government of Odisha Women and Children Department has specified the guidelines that the applicant will be a female candidate in the age group of 18 to 42. And she was then 51 years age. And the present appellant was selected in the selection procedure. And there was a stay granted in that application. Before that, the merit list was prepared and the appellant herein was selected. But the Honorable Single Judge has not taken into consideration the aforesaid.
Kindly point out from the impugned order what is the error committed by the learned single judge.
My lord, at page 38. In the context, it is to be for selection and engagement of opposite party number 4. The present appellant is by virtue of interim order passed on 3/2/2014 and subsequent order dated 21/2/2014. Hence, the opposite party number 4 is also knowing about the fact of her engagement, which has been made depending upon outcome of the writ petition. But there was an IA filed, IA number miscase number 22848 of 2014, wherein the RTI report was filed. The merit list was prepared before the interim order was passed. That is on 27/1/2014. So that was not within the knowledge of the appellant. And the writ petition therein was not at all maintainable, as there was a delay of 17 years, which was on the part of the petitioner therein, as well as the authority concerned, opposite party number 3 therein. Because when the 1997 notification was challenged in OJC 17306 of 1997, that was dismissed in 2007. After that, neither the petitioner, the respondent number 1 herein has taken any step to go for a representation and file for it, nor the state government has taken any step for the calling upon them to interview themselves.
Sir, page 40 is the operative portion of the order, correct?
My lord. My lord.
Kindly read what the operative direction is, sir.
Authorities are directed to conclude selection process which has been initiated in terms of advertisement issued in the year 1997, which was the subject of OJC number 17306 of 1997, and select eligible candidate from the panel which was prepared on the basis of the interview held on 2/12/1997.
What has happened, sir?
After I was selected.
No. What has happened after this order was issued?
I was served with a termination letter on 30/10/2015.
No. What is the selection process? Did it take place? Did it not take place?
My lord, I have no instruction in that regard because I was.
Please, that is the only instruction you have to take, sir.
Before this on the
Whom are you appearing for?
For respondent, my lord.
What is your instruction?
My lord, in this case, there was no, as per the order of the learned single judge, there was no selection after that.
At page 40, there is a direction issued by the learned single judge. Has that direction been implemented, sir?
That has been.
You are not aware.
That has been implemented. Hemlata Mahapatra has been engaged.
Oh, I see. Yes. All right. Engaged when, sir?
On 3/11/2015 and joined on 7/11/2015.
All right. You see, it is seen that pursuant to the direction issued by the learned single judge in the impugned judgment, a fresh selection, in fact, was completed. The fresh selection process on the basis of the interview held on 2/12/1997 was completed, and one Hemalata Mahapatra.
She was the original petitioner in the
respondent number 1 here who was a writ petitioner, has been engaged, and she joined on
2015, my lord.
7/11/2015 itself. Full stop. In that view of the matter, the impugned order has worked itself out with the status quo continuing for more than 7 years now. This court is not inclined to interfere at this stage. The writ appeal is accordingly dismissed.
Item number 17.
What is the delay you said? That earlier matter?
17-8.
The delay is condoned.
17-18 similar matters shall also be fixed to 19th October 2000.
All right, list on 19th. All right. 17th and 18th, list on 19th October. Right.
Item number 19.
So 18 and 19, no, 17 and 18. All right. Item 19.
My lords, may I please your lordships? My lords, this writ appeal, lords, I want 2-3 days time because I'm getting some problem with the file. It's not in order.
We're not adjourning, sir. Sorry.
So let's then I may face some difficulty and still I am assisting a lot. This writ appeal has been directed against the order dated 11/12/2015 passed by the learned single judge. My lords, the learned single judge, while dismissing the appeal, did not consider the fact that the impugned order before the trial, before the single judge, honorable single judge, was an order passed without affording any opportunity or any notice even. Two, that petitioner was not a petitioner before the single judge, was not a
So how is a writ appeal maintainable, sir?
This was against an administrative order. According to though the single judge says that, but the order was
it clearly says it's under 227.
He says that is also not, there's an administrative order. I was occupying a land and with giving my royalty and value, and thereafter they cancelled it. Then I challenged the cancel, not seeking a mandamus to quash the same.
So there has been no stay of the impugned order of this single judge.
Before the single judge, it was there till the
during the pendency of this writ appeal, there has been no interim order.
No interim order.
So you have been out of the shop for the last 7 years.
My submission before lordships that the question that holds up, that if a particular authority for his livelihood allotted a land and was labor license, other food license, or other, he was continuing with his livelihood, without any reason, if a cancellation is made, then it even for the sake of argument that they want that particular place for some other purpose, a legitimate expectations of the appellant is that he must be given his livelihood, some alternative places. In this case, though that I raised before lordships that I was truly protected till the end of the writ petition of lordships by word of interim order, but admittedly that in the appeal, government has been asked to take instructions and but no interim order of injunction or stays there. But the petitioner has lost his livelihood. What was his mistake? If you come to the impugned order, you will know it, sir.
Para 3 mistake is
so in a writ appeal, normally, sir, in a writ appeal, you have to refer to the impugned order of the single judge and tell the bench what is wrong with it. That is the argument of writ appeal, sir. So if you can kindly do that, sir, it will help us.
The paragraph 3 of the impugned order, your lordship may see, the impugned order before the learned single judge was dated 12/6/2003, by which I was asked to vacate and to do. But through their counter, they annexed one document saying that there was some report. I will show that particular. That was after 6 days of the impugned order. But first they evicted us. Thereafter they created a document that is 19/6 learned single judge didn't appreciate the same. Your Lordship may see 12-6 to the first paragraph of the order. 12-6-2003 was the impugned order before the learned single judge, and the letter by which the allegation is made, that spot visit, that was dated 19/6/2003. And your Lordships, if I go to that order, that is Annexure 7.
Anyway, it's a temporary allotment for 1 year, sir. That's all.
And
Sir,
the condition was that he will not be entitled to any prior notice and no reason
Correct,
is to be
correct,
assigned. It was purely a temporary
That's right.
license, not a
Correct.
lease.
Correct.
But
The
way I
appellant was granted a purely temporary license on
But I
19
was
May
confused from all the-
1994 for allotment of a space at the bus stand in Koraput for 1 year. Full stop. He was only allowed to construct a temporary structure for his hotel purposes. Full stop. It was made clear that the authority has the right to cancel the license. For violation of the terms and conditions of the license. Full stop. For some reason, this arrangement continued till 2003, till 13 June 2003, when the impugned order was passed, required him to remove the structure and deliver possession of the site. Paragraph. Although in the impugned order of the learned single judge, a reference is made to a report submitted by the Chief District Medical Officer on 19 June 2003 of the unhygienic condition of the hotel in question. The court finds that the original term of the license itself made it clear that it was temporary and only for a period of 1 year. Full stop. Therefore, irrespective of the report of the CDMO, the appellant could not have insisted on continuing in the structure in question on the basis of any single court's legitimate expectation. Full stop. Consequently, the court is not inclined to interfere with the impugned order of the single judge. The writ appeal is dismissed.
Item number 20.
This case, my lord,
Delay.
the petitioner
Delay.
was a Sikhya Sahak. Though there was no service condition for transfer or deputation, she was deputed to an institution and accepted that and joined there. But after a few days, it was cancelled. And that cancellation he has asserted before this honorable court, and that was there was an order of status quo. And virtually there was no relief order. He was
Sir, what continues now? What survives today, sir?
no, he is dismissed. Problem. Just and that point, I'm just because he didn't join there and approach this honorable court, they proceeded and terminated him service.
That's a different cause of action.
And that is the cause of action for which he has come.
No.
Yes.
Writ appeal. The writ
Yes,
appeal, what
writ
is
appeal.
challenged?
Yes, that order of dismissal says to the honorable single judge.
Tell us what is wrong with that
was
order.
the-
Tell
that
us what
was
is wrong with that
dismissed.
order.
Yes, that time coming. There, the honorable single judge has held, and you see Annexure 8. That is the order impugned. Page 28. The honorable single judge has held, since it is a contractual appointment, you are not to be given opportunity of being heard. Whatever the procedure they have followed, that is final. And accepted that order of termination. That order against I have come. Therefore, I was stating my fault because I didn't join and approach the court of law, and they proceeded and dismissed me from service. That was the cause of action. And the termination is a very,
Please come to page 33, sir.
yes.
Actually, you can start at 32 after having heard learned counsel. Bottom of
The
page
admitted-
32.
The petitioner, even after order dated 20, my lord want to.
Bottom of page 32, sir.
Oh, 32, sorry. After having heard of such parties and on perusal of the documents and record, the admitted fact in this is that the petitioner was deputed to Sulu Maha Project Upper Primary School by the order dated 7/12/13, but subsequently the order posted was cancelled by the order 6/9/14. Petitioner immediately after cancellation of the order of posting by order dated 6/9/14 has approved this court by WPC number 15549 of 14. The writ petition was disposed of with an interim order to maintain status quo. The petitioner, after the order passed in WPC so-and-so, has approved before the OP number 6 for permit her to resume her duty, but joining report was not accepted on the pretext that she was already been relieved on 15/9/14. This is the fact I was stating.
Kindly read on, sir.
Pardon? Yes. Further admitted position is that the petitioner never approved before the place where she was posted prior to issuance of the order dated 6/9/14. The collector, in pursuance to the order passed by the WPC 17549 of 14, has taken final decision, annexure 4A, rejecting the claim of the petitioner, directing to join her in the parent school as per the order dated 6/9/14 of the block education officer, Daringbadi. The petitioner, even after the order dated 26/2/50, has not taken any steps to resume her duty in Adipadara Primary School. Therefore, so-called notice was issued asking the petitioner to give a reply as to why she has not disengaged by notice dated 18/3/15, annexure 14. The petitioner has given due reply on 30th March 15. From perusal of the so-called reply, point which has been taken by the petitioner is that since he was not relieved in pursuance to the order dated 6/9/14, hence he has not resumed her duty. But that fact cannot be accepted because of the petitioner has again moved to this court, even after rejection of the order of the collector dated 26/2/15, by preferring a writ petition before this honorable court bearing WPC 4531 of 15, which was disposed of with the direction to reconsider, and in pursuance to the direction of the collector has passed order. The collector, pursuant to the order passed in WPC 4531/15, has issued notice to the petitioner to appear before him. Accordingly, the petitioner along with the other parties had appeared the prayer of the petitioner, prayer of the petitioner dated 4/3/15 as received in office collector on 2/4/15, where she has prayed for reconsideration of the order passed by the collector on 26/2/15, which was passed in pursuance to WPC number 4531 of 15. Collector, after considering the stand of the petitioner, has come to a definite finding that even after the order at 26/2/15, she is continuing at Sulu Maha Project Primary School by maintaining a separate attendance register. The contents of the petition regarding not relieved on 15/9/14 was also been inquired by the collector on verification of the record, and he came to finding that the petition was actually relieved on 15/9/14, but when she didn't receive this relief order, the same was sent by her post. However, the petition was going to the Suluma Project Primary School, but the headmaster didn't allow her to sign the teacher attendance register. It was also came on record that the petition was posted to Adipadar Primary School in the year 2012 and joined on 15/11. Subsequently, she was deployed to Suluma Project Primary School by the order dated 7/12/13, joined there on 16/12/13. By the order dated 6/9/14, the deployment order was cancelled in view of the decision of the district transfer Rationalization Committee. According to the headmaster Suluma Project Primary School, relieved the petitioner 15/9/15 by virtue of the office order number 31 15/9/14, but the petitioner had approached this court in WPC 17549 of 14, and the pursuant to the order passed by the said writ petition, the decision was taken by the collector by rejecting the claim of the petitioner by the order dated 16/2/14. The collector, after taking into consideration all aspects of the matter, has come to a finding that petitioner has got no regard to the order of the higher authorities. He has commented that when she was not being permitted to resume her duty in Suluma Project Primary School by the headmaster, he started maintaining a separate attendance register. It has been pointed out to the impugned order that the petitioner has got no regard even to the respect of the order passed by this court, because when this court has passed an order in WPC 17549 of 14 directing the collector to take decision, according to collector has taken a decision rejecting the claim of the petitioner, but the petitioner has not given any compliance of the said order. Rather, she has again filed a fresh writ petition before this honorable court, which suggested that petitioner by hook or crook wanted to remain in Suluma Project Upper Primary School. However, and counsel for the judge has argued that she was not allowed to resume her duty after 26/2/15 pursuant to the order passed by the collector. She has been brought this fact to the knowledge of the collector in Act 11. But the collector has not taken any action in this regard. Although the content of Annexure 11 is in Odia language, the translated copy of the same has been filed. Office directed to keep the same on record. The content of the Annexure 11 is that the headmaster of the school disobeyed the order of the noble court, refusing me to sign in the attendance register, and he has not paid any arrear salary. So that I filed contempt case by order number 1072/2014 before the Honorable High Court. Now it is sub judice. I am working in this school now. I have not relieved till yet in this situation. Now I can work at school, leaving this school. The content of the annexure 11, which was written on 4/3/15, also suggested the fact that the petitioner was not willing to join in Adipadar Primary School. In view of these facts, considering the conduct of the petitioner, considering the nature of the engagement of the petitioner, which is purely contractual, she cannot be allowed to flout the order of the higher authority regarding refugees in subordination. The collector, after taking consideration of all the aspects, this matter has passed a well-reasoned order, hence the same doesn't warrant an interpretation by this court. This is the order, madam.
All right. We'll pass the detailed order. There's no merit in this writ appeal. It's dismissed. Yes.
Supplementary list item 21.
Even pass on, my lord.
May I please? Yes. Pass on.
Item 22.
Lord, may I please, your lordship? The delay is 579 days. Lord, I have already filed petition justifying the delays.
Let's see what justification it gives.
Lord, only that is that a review period that has been treated counted as a delay period. That I had filed a review application challenging the order, and the review period has been calculated, and that has been pointed out by the sir that the 790 days. But actually, if that review period that will be excluded, that is only 49 days. But the case is like this, Miller. The petitioner being in the writ application prayed for regularization of his service in the OHPC, Odisha Hydropower Corporation, Miller. Miller, in this case, the OHPC had in its
Sir, has there been
19th meeting.
Can I ask you a question, sir?
Miller.
In this court, in the division bench,
Miller,
has there been a stay of the impugned order of the single judge?
No, Miller, a notice was issued for a limitation, and this has come for the first time.
So no stay has been granted.
No
correct?
stay has been granted.
So have you implemented the order of the single judge?
No, Miller, since writ application is pending, that's why the order.
No.
has
What is
not
the
been-
order under challenge? Which order you challenge, sir?
Miller, the order dated annexure 2, Miller, that is 25/4/2014.
What does that order require you to do, sir?
Miller, the order has been, direction has been given to regularize the service of the petitioner, Miller.
Sir, have you implemented that order?
No, Miller, that has not been implemented since the writ application is pending.
Is there a stay, sir?
No, Miller, no.
Then you have just assumed that you don't have to implement.
No, Miller, that is not the fact, Miller. The review challenging that order because of one material fact that was not.
So with there being no stay, what is the legal position, sir? Try and explain to us. If there is no stay granted of a single judge's order, does that order require to be implemented, sir?
But that will be implemented.
So would you want to implement it, sir? You say during the 7 years of the present writ appeal, there has been no stay of the impugned order of the London single judge requiring the appellant to regularize the services of the respondent. Full stop. Despite there being no specific order of stay, it appears that the appellant has not implemented the impugned order. Full stop. This despite the fact that a review petition filed against that order was dismissed by the London single judge on 5th October 2015, again by a detailed order. Full stop. That apart, having carefully perused the impugned orders, impugned original order passed on 25th April 2014, as well as the review order passed on 5th October 2015, the court is unable to find any error having been committed by the London single judge. Consequently, the court is not inclined to interfere. The writ appeal is dismissed. That contempt case, the order now be implemented without any delay. The contempt case is disposed of.
Item number 23.
My lord, Simon VC, I am permitted to place the petitioner challenged the order under Annexure 2 and also under Annexure 4, my lord. Annexure 2 that is running page 151, my lord. That while disposing the writ petition, my lord, the honorable court, my lord, did not consider main prayer.
Sir, how much is the delay, sir?
173 days, Your Lordship.
What is the explanation, sir?
Lordship, the explanation is at page 3, immediately before the prayer, Your Lordship.
He said there's a delay of 173 days in filing the present appeal. The explanation offered in the application is wholly unconvincing. Consequently, the court is not inclined to. As a result, miscellaneous case so-and-so is dismissed. Consequently, the appeal is dismissed.
So I'm for the open number 4, Your Lordship.
All right.
Item 24.
My lord, item 24. May I please your lordship, in the present case, my lord, the conducting lawyer, Mr. Mishra, has expired on 24/6/2022, my lord. In the meantime, also, his clerk also expired, my lord. I may be allowed 2 weeks' time to take instruction in this matter.
Where are you, sir? Who are you? What is
I have the power, my lord. I am for the university. I am from the university.
Tell us what the matter is about.
My lord, in this case, my lord, the petitioner, the appellant, challenging the order passed by the single judge in OJC number 8914 of 2000, that is on the ground that this honorable single judge has failed to appreciate that the respondent was appointed against a suspension vacancy of Sri K.C. Panda as system engineer. After reinstatement of Sri K.C. Panda, the continuance of the respondent was not required and there was no vacancy to accommodate him. Next round, my lord, the honorable single judge has not taken into consideration that there was no necessity for holding inquiry before passing order of termination, since the same was a termination simpliciter, my lord, without casting any stigma on
but you served a charge sheet on him, sir. Come to para 8.
Para 8.
Page 32.
A contention has been raised by the university that there is no necessity for holding inquiry before termination of services of the petitioner, as the order of termination, as in Annexure 7, is simpliciter 1. Neither it was punitive, nor does it cast any stigma on the career of the petitioner, that there was no post and he was appointed against a suspension vacancy, and that he had no right to the post, as he had not the qualification for the post of system engineer. The petitioner having been selected and appointed by the following due procedure, at this point of time, it is not open to the university to having done all with the wide open. The charge was framed against the petitioner by Annexure 4 on 28/9/1999, and on that basis, inquiry was initiated. But at the midst of the inquiry, the order of termination has been issued by Annexure 7. After the charge was framed, the petitioner sought for supply of document, more particularly reported of the RDC, basing upon which the entire action was taken for termination services of the petitioner, but by Annexure 5, dated 22/5/2000, he has been denied supply of such report on the plea that the same is confidential. Even if the petitioner sought for other documents, the same has also not been supplied to him. This clearly indicates that there is
the present
violation
appeal. All right, sir. The present appeal is directed against a judgment dated 4th August 2015, passed by the London single judge, allowing writ petition civil 8914 of 2000 filed by the respondent. Questioning an order dated 4th September 2000 passed by the appellant university terminating his services. Paragraph. One of the contentions raised by the present appellant to defend the order of removal was that the engagement of the respondent was purely contractual and the order terminating his services was non-stigmatic. This has been negative by the learned single judge by observing that the respondent had in fact been issued a charge sheet by the present appellant. And even before the inquiry could be concluded, his services were terminated without even supplying him the documents on the basis of which the inquiry was initiated. Secondly, it has been found that the respondent was engaged pursuant to an advertisement issued against a clear-cut vacancy of system engineer. Full stop. The respondent had applied and was found suitable and was accordingly selected and appointed. Full stop. Consequently, the contention of the university, appellant university, that he was appointed on temporary basis against a suspension vacancy and that his termination was a simpliciter one, was rejected by the learned single judge. Paragraph. Indeed, if a charge sheet had been issued to the appellant, to the respondent, and during the pendency of the inquiry, his services were terminated, it could not be contended that this was non-stigmatic. The court is unable to find any error having been committed by the learned single judge in passing the impugned order. The appeal is accordingly dismissed.
Supplementary item 25.
Delay.
May I please? Hearing this case, my lord, the petitioner of the general public, they have filed this writ petition challenging the order which has been passed with only single judge, my lord.
What is the delay, sir?
Page 13, my lord.
Sir, can I ask you a question?
Yes, much obliged.
What is the delay in filing the appeal, sir?
Yes, I have categorically mentioned in para 2 or 3 of my limitation petition, my lord.
How much is the delay, sir?
Delay that I came to know on 1/12/2015 and thereafter applied certified copy.
How many days delay, sir?
Exactly. I have not calculated.
We have calculated, sir. Fortunately, the registry has calculated. What is the delay, sir? Sir, delay is 276 days.
My lord.
What is the explanation,
Yes,
sir?
my lord. May kindly see the petition which has been filed by me in condonation of delay in para 3. May I place, my lord? May I place to that extent regarding that delay, man, which I have mentioned in my limitation petition with the permission to that extent, my lord? That the petition of the villagers of village, when opposite party number 1 tried to encroach the land in question 1/12/2015, my lord, the petitioner inquired about the matter from the OP number 1 and he disclosed, showing a copy of the order of this honorable court in which order of respondent number 2, that is RDC, has been quashed, as a result of which the order of the opposite party number 3 is confirmed, which is Tahsildar, my lord. As a result of which a property in question used by public has been settled illegally in favor of the OP number 1, as a result of which villagers are going to be affected. The petition was immediately applied certified copy through the advocate on 3/12/2015 and due consultation with the advocate was forced to file this writ appeal, my lord. This is the explanation by the villagers.
There's a delay of 276 days in filing the appeal. Explanation offered for the delay is extraordinary delay is not convincing at all. In any event, there's no explanation of every day's delay in filing the appeal. Consequently, the delay is not condoned. The appeal is dismissed.
So far that one thing.
Item 26.
Is a communal land that is meant for village. To that extent, the villagers are going to be affected, my lord.
None appeal is dismissed.
Item number 27.
Item 27, my lord. The order of the signature has already been complied.
It is stated that the appeal has become infructuous. It's disposed of.
Contempt is there. There is a
Contempt petition is disposed of. Right.
Item number 28.
None appeals dismissed.
Item number 29.
29, my lord, not pressed.
Not pressed dismissed.
Item number 30.
None appeals dismissed.
Item number 30.
Item number 30, your lordship.
I am appearing for the petitioner. I think by efflux of time it has become.
All right. Counsel of the appellant states that the appeal has become infructuous. It is disposed of as such.
My lord, in this case, we are appearing for OPU number 4, DP Dhol and Associates.
31.
In item number 30, your lordship.
Item 30.
31. All right. 30, none appears. 31, infructuous.
Item 32.
Look at it, wearing a senior gown.
Item number 32.
None appears dismissed.
Item number 33.
None appears dismissed.
Item number 34.
None appears dismissed.
34. Item 35.
This has become infructuous.
35, infructuous dismissed.
Item number 36.
None appeals.
Item number 37.
37, my lord, it is against the order of the Honorable Single Judge that arose out of one accident claim case. One amendment petition was filed that was recused. That is why writ was filed. Writ was also dismissed. In the meantime, that claim case has been disposed of. So the matter stands infructuous.
Writ appeal has been rendered infructuous. It is disposed of as such.
Item number 38.
Dismissed. None appears dismissed.
Item number 39.
Item 36, my lord, pass over, my lord.
We've already crossed that, sir. Right.
My lord. Item number 39, my lord. With great respect, my lord. Item 36, pass over, my lord.
All right. 26 pass over.
Item number 39, my lord. Matter is become infructuous.
39, infructuous dismissed.
Item number 40.
Your lordship, item 40, we have no instructions.
No instructions dismissed.
40. Item number 41.
My lord, infructuous.
Infructuous dismissed.
Item number 42.
May I please, your lordship? My lord, here with your lordship's kind permission, I beg to file only a small date chart. My lord, for your lordship's kind appreciation. Your lordship will also kindly peruse order dated 27/2016 passed by Dishonorable Court in this writ appeal. With reference to the decision of Dishonorable Court, the appeal was admitted. Here, my lord, what has happened? May I just place the jet chart with your lordship's kind permission, my lord?
Yes.
My lord, on 6/7/1977, the father of the respondent number 1, namely Rupai Behera, executed deed dated 6/7/77 in favor of the mother of the present appellants, specifically mentioning in the cell deed that she is neither scheduled caste nor scheduled tribe. On 12/11/77, the present respondent number 1, son of Rupai Behera, claiming to be Koibarta by caste, obtained a caste certificate bearing number so and so dated 12/11/97, and that is 97, I'm sorry, my lord, from the Tahsildar Tirtol. Respondent number 1, along with his brothers and mother, filed a petition under section 22 and 23 of the OLR Act by OLR case number 3 of 97 for recovery of possession of the land sold to the mother of the present appellants on 6/7 on the ground that the cell deed is prohibited in law. The present appellant, on coming to know about such act of the respondent, preferred certificate misappeal number 2 of 2001 before the district magistrate cum collector Jagatsinghpur. OLR case number 3 of 97 filed by the respondent number 1 was allowed, against which an appeal has been preferred by the appellants bearing number 2 of 2022 before the ATM Jagatsinghpur, which is pending disposal. The certificate misappeal 2 of 2001 was allowed by the collector, concluding that Rupai Behera was not a scheduled caste person, and accordingly the collector directed the cancellation of the caste certificate. WPC number 47 of 2006 was filed in the order passed by the collector in certificate misappeal number 2 of 2021.
Only a remand order, Mr. Mishra.
That is a remand order. It is a remand order. There is a clear observation of the single judge. And the collector will act upon it.
No, I'll just point out what is the fallacy. Unless that is clarified, there will be difficulty. And that is why, my lord, the writ appeal was entertained. Page 28, your lords may kindly turn to. On what basis the remand has been effected? There has been a concluding finding which will, my lord, create problem. Your lords may kindly see. May I just, with your lordship's kind permission, place subpara 3 last 3 lines?
Yes.
Since the amendment has retrospective effect, the appellant authorities shall consider the same and heard the appeal afresh after giving an opinion.
Yesterday we had hearing this matter.
That, my lord?
We were hearing this matter yesterday, sir. On this Kaibarta, Kevta, Devara.
Therefore, your lordship may now kindly refer to the judgment of this noble court. Even assuming this will have a retrospectivity, it's from, my lord, 5/11/1979, as per the judgment of this noble court. And Honorable Apex Court has been pleased to categorically hold that this will have a prospective effect, and that prospective has been by this noble court from 5/11/1979. If that is so also, I am safe because the sale deed was of the year 1977. This aspect has not been taken into consideration.
No, but he does belong to a scheduled caste, sir.
No, he was included by virtue of 2002 amendment. So by then, sale had already been effected. Sale was of the year 1977, and it will not relate back. That is where the difficulty lies. The Honorable Single Judge has said it will have a retrospective effect. So that is my grievance. Your lordship will kindly see. Not only that, so what I beg to submit, it was included only.
All right, we'll ask them to independently consider without taking into account this observation.
No, my lord, the other
grievance in the present appeal is that while remanding the matter to the appellate authority, the learned single judge has, in the impugned order dated 11th December 2005, referred to the notification dated 18/12/2002, including the caste of Devar, Dibara, Kevta, and Kaibarta as part of the scheduled castes, and observed that the said amendment would have single court's retrospective effect. Unquote. It is submitted that this observation will hurt the present appellant, since the question whether the said amendment would have prospective or retrospective, it is not a settled one. Paragraph. Considering that the learned single judge was simply remanding the matter to the appellate authority for a fresh consideration, there was no occasion to observe on the prospectivity or retrospectivity of the notification dated 18/12/2002. Stop. That has to be considered by the appellate authority independently. Stop. Consequently, while clarifying that the above observations in the impugned order of the learned single judge concerning the single court's retrospectivity in court of the notification dated 18/12/2002 would not influence the decision of the appellate authority on remand, the appeal is disposed of.
Obliged.
Item 43.
The interim order is vacated. None appears dismissed.
43 will also become infructuous.
Infructuous dismissed.
Item number 44.
None appears dismissed.
Item number 45.
May I please? In fact, there is 16 days delay, Your Lordship.
Or delay is condoned. Yes, tell us what the matter is about.
Matter, my lord, the issue involved in this case, Your Lordship, whether the liability of the subsequent purchaser to pay the arrear outstanding of the previous owner. In that matter, Lordship, the previous owner has a arrear outstanding of 3,94,000 some odd amount. And there was also an assessment proceeding initiated under section 126. And there was 5 lakh some odd amount there is outstanding. The property was sold on auction by the OSFC. The petitioner,
So how does the arrears go with the property, sir? Why should the new auction purchaser pay the arrears?
My lord. And in that matter, the respondent purchased that property and he paid some amount for his area outstanding. We provided power supply when that assessment proceeding was the subject matter of the consumer forum before the Lorna District Court for Malpur, that was dismissed. Against that, the previous owner moved an appeal before the State Consumer Forum, that was dismissed. And that agreement, your lordship, that is your lordship, the agreement condition that is executed in between the parties, that stipulates that will be recovered from the subsequent purchaser. The agreement executed, that is annexure, page 27, your lordship. The second proviso that they provided that all ancient liabilities under the old and or superseded agreement above shall be treated as arrear and liabilities under the present agreement.
It does not talk about electricity supplier.
And my submission for lordship is that when you issued a disconnection notice,
Single judge, sir. This is a writ appeal. Come to the order of the single judge.
Miller, that is the cause of action. The honorable single judge.
So kindly come to the order of the single judge, which page that is, and tell us what is wrong with the order of the single.
Miller, your lordship. Your lordship, kindly glance page 64, paragraph 3. That I submitted, P.K. Tripathi, Law and Counsel for the petition submits that consumer opposite is bound by clause 9 of the agreement dated 5/12/2000 executed between the parties under Annexure 4. He further submits that against the order of disconnection.
That's a submission, sir. Where is the finding?
Finding, your lordship, finding that is at page 66, paragraph 7.
Yes.
On perusal of the agreement annexure 4, it appears that consumer has been called upon to execute the agreement for availing power supply. The same being a standard form, the petitioner has put his signature to abide by the conditions stipulated therein. But it reveals that clause 9 having been typed out separately and incorporated in the agreement itself through the standard form, clause 9 deals with the stamp duty. Therefore, incorporation of clause 9 in the agreement directing that the opposite party has to bear the liability of the previous consumer creates a doubt with regard to the conduct of the petitioner who might have done so by using external pressure. In any case, the incorporation of clause 9, which has been typed out and inserted into the standard form, to which both parties are the signatories of the same, whether the same has been done by using external pressure or coercion, this court expressed no opinion at this point of time, as the same has not been challenged at any point of time. This question can be considered by an appropriate forum if the consumer so likes. Second, your lordship, by time of the paragraph 8, by time of petitioner executed the agreement on 5/12/2000 in exercise of power conferred on subsection 2 of section 9 and section 54 of Orissa Electricity Reforms Act 1995 and all other powers enabling it on that behalf, the Orissa Electricity Regulatory Commission relation to govern distribution and supply electricity and procedure thereof, such as the system of billing modality, payments, bills, powers, function, obligation, suppliers, and right of obligation to consumers matters connected thereto to incidental thereto. Regulation 10 and 14 of Orissa Electricity Regulatory Commission Distribution Code 1998 that provides clause 10 and 12, 14, your lordship. The law and single judge hold that is page 69, paragraph 12, your lordship. By virtue of the amendment, 2004 proviso to regulation 1310B has been omitted by virtue of notification issued under Annexure 1 has got prospective application. It appears that consumer opposite party has purchased the property in question, took over the possession on 1/12/2000. The amendment came into force on 18/10/2010, your lordship. Where the premises came to owned and occupied by the auction purchaser and such purchaser seeks supply electricity energy, he cannot be called upon to clear the past arrears as a condition precedent to supply. There is no charge over the property. What matters is the contract entered into between the S12 with the supplier. Therefore, supplier cannot seek the enforcement of contractual liability against the third party. That is the finding, your lordship. I am submitting one. First of all, single judge though hold that the agreement stipulates a condition that has not been challenged, that is binding, Your Lordship. The agreement always stands, then consumer is liable to
Not
pay.
vis-a-vis you, sir. The agreement is not with you.
And second is that, so far the third party contractual liability is concerned, Lordship, one judgment, recent judgment of Supreme Court, Lordship, kindly Telangana State Power Distribution Company versus Sigdha Beverage, Lordship. After discussing the all judgments as on date, you Lordship kindly glance paragraph 15. We have gone into, may I read, Your Lordship?
Yes.
We have gone into the aforesaid judgment as it was urged before us that there is some ambiguity on the aspect of liability of dues of the past owners who had obtained the connection. There have been some differences in fact, but in our view, there is a clear judicial thinking which emerges, which needs to be emphasized, that the electricity dues, where they are statutory in character under Electricity Act and as per terms and conditions of supply, cannot be waived in view of the provision of the Act.
Where is the auction notice here?
Auction notice 1/12/2000.
Which page?
Auction notice that was not subject matter challenge for Lordship.
No, not for challenge, sir. There was a clear clause in the auction notice that it is on an as-is whereas basis.
The fact remains that, Your Lordship, in auction 1/10/12/2000, the respondent took over the possession of that property.
Was there a condition like this, sir?
On 4/8/2018, Your Lordship, 14, that demand was issued.
After 14 years.
That demand was challenged before the JRF.
After 14 years, sir.
That demand was challenged. Within the knowledge
was belated, sir. Highly belated. Such a demand is highly belated.
No, by the time what happened, Lordship, by the time it was within the knowledge of the respondent that there was a pending case before the District Consumer Forum, Lordship. Because of that reason, Lordship, Annexure 6 series, Lordship, kindly glance.
All right. The short point involved in the present appeal.
For a moment,
which is directed. We've heard you, sir. You heard it at length, which is directed against an order dated 1st December 2015, passed by the single judge. In which page is the single judge? Writ petition civil 8922 of 2015, filed by the present appellant, rejecting the writ petition and upholding an order dated 5th February 2015, passed by the Grievance Redressal Forum (GRF) Burla in GRF case number 169 of 2014. Quashing the demand raised by the present appellant. Full stop. The admitted facts are that the respondent, Messrs. Ma Tara Rice Industries Private Limited, took over the erstwhile unit of an earlier consumer of the present appellant, Messrs. Jagannath Rice Industries, on the basis of an auction purchase pursuant to an advertisement. Public notice issued in this regard on
OSFC, by OSFC on 1/12/2000.
On 1/12/2000. Full stop. The question that arose before the learned single judge was whether the subsequent purchaser could be made liable for the electricity use of the previous consumer. Full stop. The learned single judge has, in an elaborate judgment, answered the question in the negative. After perusing the agreement executed between the previous owner, consumer and the current and the auction purchaser. Full stop. The learned single judge is also referred to Regulations 10 and 14 of the Orissa Electricity Regulation Commission Distribution Conditions of Supply Code. Counsel for the appellant sought to place reliance on the judgment of the Supreme Court in Telangana State Southern Power Distribution Company Limited versus Shrigda Beverages, AIR 2020 SC 2676, to urge that the subsequent purchaser would be liable to clear the dues, electricity dues of the previous owner. Paragraph: the court is unable to agree with the above submission. The perusal of the judgment reveals that in the facts of that case, the e-auction notice in question clearly mentioned that the sale would be on single quotes as is whereas basis, as is whereas, whatever there is and without recourse basis, unquote. In the present case, there is no such clear indication in the auction notice, and therefore the appellant cannot the case of the appellant is not in no way assisted by the above judgment of the Supreme Court. Paragraph: in the present case, the agreement between the parties was clearly not in contemplation of electricity dues, as is evident from the wording of the particular clause in the agreement. In previous dues, previous liabilities of regarding the liabilities of the erstwhile owner. Full stop. In the absence of a specific clause concerning electricity dues, the present appellant cannot compel the subsequent auction purchaser to clear the dues of the previous owner. There is no error committed by the learned single judge in dismissing the writ petition of the appellant by the impugned order. Full stop. Consequently, the appeal is dismissed.
Item number 46.
Delay, sir. 980. There's a delay of 984 days, which has not been satisfactorily explained. Accordingly, the application is dismissed. The writ appeal is therefore dismissed.
Item number 47.
47, my lord. Petitioner expired, my lord.
Counsel for the appellant states that the appellant has expired. Consequently, the appeal is dismissed as abated.
Item number 48.
None appeal is dismissed.
Item number 49.
None appeal is dismissed.
Item number 50.
None appeal is dismissed.
51.
None appeal is dismissed.
Item number 52.
None appeal is dismissed.
Both. Item 53.
None appeal is dismissed. Both matters.
Item number 54.
Item 52. Item 52 infractions, my lord.
52 infractions dismissed. 54 none appears dismissed.
54, your lordship, the brief has been transferred.
All right.
We are appearing for the Union of India.
All right.
Supplementary list fresh admission, item 55.
My lord, one pass.
Pass.
Item number 56.
56 may please, my lord. This is a public interest litigation, my lord. Here the petitioners has come before this honorable court, my lord, for protection of the Amrutamani property of Lord Jagannath, my lord. Earlier,
there are enough matters here.
My lord, pardon.
There are several matters. This is where are these properties located, sir?
My lord, so we have earlier approached before this honorable court by WPC number, my lord.
No, where property is located?
Property at Aneswar 1, my lord.
Sorry?
Aneswar 1, place
district. Cuttack district.
Cuttack.
Cuttack district, my lord.
Earlier you filed 14752.
My lord.
Where is that?
That order? Has been disposed of the impugned order as page 91, my lord.
91?
91, running page 91. But the operational portion of the order, my lord, at page 96. And I have also quoted in the writ petition, the order also I have quoted in the writ petition, my lord.
No. Where is the order pursuant to the previous order?
That is 96, my lord.
No. 96 is this court's order. Pursuant to that order, there must have been an order passed by the RDC. Where is that order?
No order has been passed, my lord.
You should have filed a contempt petition.
My lord, because of 1 year has already been elapsed.
So this doesn't mean that you should file an application for delay then.
Well, because
don't have an alternative route like this, sir.
Because because earlier one application by
no, then it's res judicata. Succeed in the earlier writ petition.
No, we have made a grievance. The Dishonour Court has directed to take a dishonour grievance.
Correct.
We have communicated by
file a contempt,
7 and 8, my lord.
You should have filed a contempt, sir.
Because another application
multiplying petitions.
No.
Earlier, the writ petition had been filed by this very petition.
For a moment, my lord, can it be? Because earlier one occasion we have come after 1 year.
That's not a reason to entertain another writ petition of the same.
Dishonour Court observed, but after 1 year the contempt is not maintainable. That's why I am filing.
That is there. Yeah. That is so you didn't file the contempt petition in time. You want to again
fresh causal action, make a fresh representation.
Because same writ petition, same prayer.
Yeah. There is an earlier writ petition. Civil PI
another grievance
filed by the present petitioners, in which order has been passed on 18/11/2019 by this court. Requiring the respondent opposite parties.
Pardon, my lord, may I pray another thing, my lord?
To dispose
I may be allowed to make a fresh grievance before the...
You do that, you withdraw this, sir. Counsel for the petitioner seeks leave to withdraw the present petition. Liberty, other appropriate remedies as may be available to the petitioner in accordance with law.
I'll file...
Disposed of is withdrawn, is liberty is prayed for.
Yes. My lord,
57. Item number 57.
May I please, Your Lordship? Lordship, this is an PIL challenging order dated 26th May of 2022, issued by the opposite party number 2 for affixation of HSRP number plates, Your Lordship. Your Lordship, Your Lordship may kindly come to Annexure 1, the impugned order. The impugned order is passed by opposite party number 2. Pursuant to Rule 50 of CMV rules, which prescribes for fixation of HSRP. And this is pursuant to the central government notification of 2018, Your Lordship. The state government, after 4 years, has passed this order. And with a timeline of affixing this within 3 months. Your Lordship, there are certain grounds on which this writ petition has been challenged. If Your Lordship permits, I'll place those grounds. Your Lordship, the petitioners before Your Lordship are senior citizens. The first thing, Your Lordship, while issuing this notification, this order that is before challenge, that is in challenge before Your Lordship, no price band has been fixed. The HSRP number plates that are to be affixed, there is no price band that is fixed for issuing such number plates. Secondly, Your Lordship.
No, how is that affecting the impugned order? Just fixes some timeline by which you have to fit the HSRP. Yes.
That is the order dated 26th May 2022. And at
there's
page
some 26/9/22 also.
Yes, that has come recently. That Your Lordship says that whosoever has applied during the timeline will be exempted, and upon showing that online application will be exempted from fine. Because from 1st October 2022, Your Lordship, fine will be levied up from charging from rupees 5,000 to 10,000 for such non-compliance, Your Lordship.
When was the rule brought in? The rule, actually, this is to be implemented when the day the rule comes in itself, right?
Yes, my lord. In view of, my lord, Annexure 7, there is no apprehension of enforcement. But they have
but provided they have applied, you should have an online booking slip. Only people who produce online booking slip will not be penalized.
Yes.
What about the others who have not booked online?
But they have to book, my lord, within the timeline. Not the booking and fixation, two different aspects. If have to book by 31st, my lord.
No, what about people who don't have computers?
Right.
Your Lordship, it is not even online. Your Lordship, I'll bring to your notice, Your Lordship.
Who has been penalized? So far, who has been penalized?
Your Lordship, time is from 1st October 2022. It is yet to be penalized.
All right.
But the problem is, Your Lordship, this Annexure 7 that they say upon production of online application, this shall be exempted. But the fine levy here in Cuttack and Bhubaneswar, at least, Your Lordship, that is automatic. the cameras, they capture the violation and the levy is automatic. They will not wait for production of such online, Your Lordship. In other states, Your Lordship, such applications are online also. But in our state, it is yet to be made online. It is only offline. The problem is in rurals.
There is no online application in the rural areas.
But Your Lordship, in other states, I have the statistics with me. The other states are giving such options for online application. The problem
here that there's
no.
Yes, my lord. Here my lord, HSRP has been booked through online.
Where do you have any proof of that?
Yes, my lord. That is on my lord, purely online, my lord.
No. What about people who don't have computers, sir?
My lord, that is in view of that of Rule 50 of the Central Motor Vehicle Rules, the amendment made in the year 2018. And my lord, there are two modes. My lord, through my lord, manufacturer, they have to fix in respect of new vehicles, and in respect of old vehicles, my lord, the state is authorized to select the number plate manufacturer. Here, my lord, delay is, my lord, by tendering process, my lord, several litigation arose. The matters carried to Honorable Supreme Court, and the Honorable Supreme Court ultimately held that the scheme of HSRP be
you're giving us all your information which is not relevant to this litigation at all.
Can I intervene for a minute?
1 minute, sir. 1 minute before we permit you, sir. Before we permit you, we have a question to ask. Kindly allow us to ask.
The
problem they're expressing is you are exempting people who have booked online for HSRP from complying with the deadline, provided they produce the online booking slip. The point that is being made is there is a whole section of the Odisha population access and is unable to book online for an HSRP number plate. What is your answer to that?
The notification was made in the month of May, Millard. In the fag end of this month, the petitioner raised that question. Lordship may grant 2 days time. I'll take instruction in the matter so that the date can be extended or not.
May I place one?
But do you have an online booking facility at all? She says there is no such.
Yes, Millard. Online booking facilities, Millard.
Suppose somebody is staying in a village, somebody is staying in the
has to come to the Katak
area.
Millard, nobody is coming to Millard, registering authority for booking, Millard. It is very much itself in the mobile also.
Yes. Sir, there are a large number of people who don't know to use all this and to book online.
Well,
and all
that aspect, I will take instruction. Lordship may grant 2 days time to take instruction.
Can I intervene, Mr. Millards? I have a vehicle. According to the notification, the term extends in the end of the month. I have 7 computers in my house and office. I am trying to get, I am not getting the connection.
Yes. See, this is the answer.
Yes,
let my friend come and do it. Out of 3 vehicles, 2 I have got the number.
So instead of saying counsel of the petitioner, I'll say the practical counsel for the government, the restriction, the deadline is stayed.
Deadline, I'll take instruction. That can be extra.
Unless you make facility easy, sir, it won't be possible for people to comply. And like she's saying, it will be captured on a CCTV. You can't show the slip outside to the CCTV camera. All impractical, sir. Why do you fix deadlines like this without... First, the infrastructure has to be in place. Otherwise, it is all harassment. You see, the counsel for the petitioner raises a grievance that without putting in place a system of which enables vehicle owners to apply for fitment of high security registration plates, bracket HSRP. Deadlines have already been fixed by the Transport Commissioner, which would make it both impractical and impossible to be met. Full stop. For instance, it is stated that the facility of online booking is not available to a large section of the Odisha population. This is echoed by counsel who are otherwise present in court and have had similar experience of not being able to book online for HSRP. Full stop. Paragraph. Counsel for the you say notice, he accepts notice and seeks 2 days time for instructions. Full stop. List on 30th. You better come up with some solution.
Mild.
The only suggestion is defer it by a month or two, get your instruction in place, and then enforce it. Otherwise, you'll end up with too many cases on your hand. You will find it impossible to implement.
That
Also, one more thing, Lordship.
Fixation is implemented through manufacturer. We have nothing to say.
No, you're fixing a deadline, sir.
Yes.
You're fixing a deadline by which the HSRP should be fitted. Those deadlines you better put off till you have a proper infrastructure in place.
Imposition of time may be stayed.
30th.
My lord. Lordship may call this matter day after tomorrow.
Day after tomorrow, we call it 30th. List on 30th, 10:30. It's a dispersed for this matter. It's better you yourself come up with a solution. All right.
Supplemental list, press admission, item number 58.
May it please, my lords. My lords, this writ appeal, batch of writ appeals, is challenging the order of the learned single judge dated 22/7/2021.
Delay.
My lord, 5 of the writ petitions have no delay. 5 have delays of an average of 150 days. This is similar to the batch of writ appeals filed by the state, where the learned single judge had directed regularization without issuing notice on the very first day of hearing. The same nature of appeals.
All right.
This is
So
for the
you
municipal
just say
court.
notice. None of the other side is here in any of the matters. It's coming up for the first time.
My lord, this is for the first time.
All right.
This is
Notice on both the writ appeal and the delay. Returnable. 28th November. Notice additionally be served on counsel who appeared before the respondents before the learned single judge. Till the next date, there should be a stay of the impugned order of the learned single judge.
Oh, bless me.
Item 59.
May it please your lordships. I mean, virtual mode, my lord.
Yes, sir.
My lords, petitioner is a oil company, my lords. That is Bharat Petroleum Corporation Limited. It has issued an advertisement for appointment of a dealer in Balangir. The present opposite party was selected and the letter of intent was issued on 24/11/2017. But subsequently, complaints were received. While applying, he has to give an affidavit that no relation of his is having any connection with any oil, which unit who is supplying oil, or a dealer in an oil company, any other oil company. She filed an affidavit. Nobody is there. But complaints were received that her husband is a dealer in another oil company. Thereafter, notice was issued to her. She filed a reply, and thereafter she has filed a writ application when the LOI was recalled. The Honorable Single Judge, your Lordship, may kindly turn to page Honorable Single Judge's order. It will be clear how the husband has filed page 29. My lords will kindly see.
No, right now it's shut, is it? The petrol pump?
No unit, it has not been allotted. She has challenged the order.
You're there for
My lord. Lord, they have challenged the order.
No. This IA is filed saying it's all lying in junk. It's becoming junk due to non-operation.
They were, my lord, they were in fact tagged it to another dealer. Thereafter, I filed when the single judge, it was before single judge, the honorable single judge, if you are running it through other persons, why not give it to her?
No,
let her also operate on your terms and conditions. Thereafter, I won the case. They did not allot me this up, my lord. Now they have come up with a writ appeal. Now in the writ appeal, they have filed an application to allot it to another. Same.
No, not allot it to another. Just see the prayer in 2997.
Your lordship may finally hear this matter. Your lordship.
No, why can't the corporation itself be allowed to operate it?
The corporation is not allowed. They are not operating. They are operating through another dealer.
pillars, we operate through some individual, not that our COCO is also company owned, company operated pumps are also operated through somebody else. We only supervise.
What is your, why is this present respondent not suitable for that?
Her husband was a partner in another dealership. He has suppressed it. For that reason, it was cancelled a priori.
That matter has been settled. Your Lordship may see the single judge order that has been dealt by this on.
Your Lordship, single judge, your Lordship kindly see para 29. His application in the other pump was shut down. Some of the partners filed a writ application. Your Lordship may see how our application reads. It has been quoted. If there he says that I have resigned, funny application, para 29, that admittedly for violation of the terms and conditions and keeping in view of the marketing discipline, the oil company, dealership of the license was terminated on 31/11, challenging that dealership they have come. That admittedly the writ petitioner challenged the termination order in this writ application without implementing the present petitioner, the husband, as a party. The writ petitioner was not authorized by the partner to file this writ appeal. The writ petitioner is liable to produce authorization letter. But now he, on the one hand, he says, I am no more a partner. On the other hand, he files such a petition. How can it be treated as? And your Lordship will kindly see, page 29, your Lordship will kindly see, Annexure 1, the letter issued by other oil company.
What has happened? There's a dispute between you and your wife, is it?
No, my husband and another person, my lord, they set up a petrol pump with a partnership deed in 2005, my lord. Thereafter, my lord, my husband resigned from the partnership since 2010. Then the dealership was terminated. My lord, he filed a writ application here in High Court, challenging that termination letter. That was stayed by this honorable court. Ultimately, I was not a party. I intervened and said I am not a partner. And this court disposed of the matter. Since the continuous term, just a minute, sir, please.
I am on my legs. Let me submit. No, what he said in his application, if it makes out a case that he has resigned, then I may not have any case. One hand he says, without my consent in the writ application, I am a partner. Other hand he says, I am resigned. Can he blow hot and cold? And we are a government-owned oil company, my lords.
So that part has been dealt by the single judge. Your Lordship may see I am reading out
I have read.
No, we haven't, sir. Let him read. Para 5. As aforesaid.
My lord. Page 3, the internal page 3 of the judgment, my lord.
All right.
Paragraph 4, my lord.
Yes.
The notice advertisement inviting application was issued by the opposite party oil company on 19th October 2014. The petitioner husband had sought to resign from being a partner in the running company on 7 July 2010.
Retail outlet, sir. RO means retail outlet.
RO is retail outlet. It appears from the impugned communication that IOCL terminated the dealership on 31st January 2011, more than 5 months after the petitioner had tendered his resignation. The husband made an interim application in IN number such and such in writ application filed by the partner. The application said inter alia as follows: that admittedly for violation of the terms and conditions and keeping in view the marketing discipline guideline, the oil company dealership has license to terminated. That admittedly the writ petitioner has challenged the termination order in the writ application without implementing the present petitioner as a party. Writ petitioner was not authorized by the petitioner to file this writ application. The writ petitioner is liable to produce the authorization letter, if any. That under the fact and circumstances of the case, this present petitioner as outgoing partner is a necessary party in the proceeding or has nexus in the issue that arise from the consideration in this writ application, and therefore it should be implemented as a party in this writ proceeding. That in the present petitioner begs to submit that the writ petitioner has challenged the termination order behind the back of the present petitioner without any intimation to him. That the expedient in the interest of justice to implement the present petitioner more particularly.
So you're not severing your ties despite having resigned. You still want to intervene in that writ petition to say I have to be heard.
Yes, that is my case.
Yes. 1 minute, Mr. Das.
No further proof is necessary to establish the fact that in the said writ petition, petitioner were the other partner, the partnership fund itself known as Ma Santoshi Filling Station. As aforesaid by the order dated 16 November 2019, the writ petition of the other partner was disposed of. it will be noticed from the above extracted said order, the division bench found that petitioner continuing to enjoy the contract for last 15 years. Petitioner can only mean the partner, herein the petitioner's husband and the farm. The husband also aforesaid was added as a party only on 13th August 2019. This fact, coupled with the husband's clear contention that of the reason for wanting to have been added as a party in the writ petition, makes it clear that his partner had accepted the resignation, thereafter proceeded to run the retail outlet on his own. Furthermore, the disposal of the writ petition vacating the interim order restored the termination dated such and such. As a consequence, the said dealership stood terminated long before the notice petitioner's application in response. As such, there can be no confusion that thereafter, on interpretation regarding whether or not the family unit of the petitioner was involved in the running another arrow, the writ petition succeed, impugn communication is set aside and quashed. But I want to bring it to Lordship.
So how have you ceased to be involved in the running of the other retail outlet?
That they have taken another partner. That partner was also a Malad intervener in that writ application. That the my earlier partner, my lord, he on his basis now they have filed the writ appeal. Your lordship may see they have annexed his letter again. Again, after my lord, I succeeded here, he again wrote a letter to the company. Your lordship may see they have annexed that letter. That annexer 1.
Yes.
Annexer 1.
From our record, I am pressing it. I was pressing. Sri Jitesh Chandra Bag is one of the partners. He is the husband of the present applicant.
No, that
is annexer 1.
Your lordship may see annexer 3, page 32. My partner, my erstwhile partner, who became unsuccessful in getting the order. Now, after I succeeded, he writes to the company on 14/3/2022 that I am a partner, you don't. And on that basis, they have now again come up.
Millers, he fights the case as a, and in the other case, he fights a petition. Without my consent, they have filed the writ application. How can it be concluded that he is no more a partner?
But the writ application.
No, 1 minute, Mr. Das.
Yes.
That other retail outlet, that termination order has now become final since 2011.
No. They're challenging that they had filed the other writ application.
No, but that interim order stood vacated. Now the writ petition has also been disposed of or not?
Yes.
But Miller, still 19, it was disposed of. He had intervened saying what your lordship may kindly see. 29.
No. During that pendency of the writ petition, sir.
Yes.
He had already resigned.
No. Let's see IOCL's letter. Annexer 1. IOCL's letter dated 7th August 2018. Annexer 1. As per our records, Jitesh Chandra Bag is one of the partners of the Arrow dealership. This is for your information, please. This is the ROCL likes. He is the earlier oil company where he is a partner. The rejection was in 2014, Milords. It needs reconsideration, Milords. I am not.
No. Today that writ petition has been dismissed, correct?
That has been dismissed in 2019.
So 1 minute, sir. So 2019, the writ petition is dismissed. That termination of the RO becomes final.
Yes.
So as of date, as
on 14, he was a partner. We had rejected on that ground. We can again re-advertise it. That is separate thing, brothers. On 2014, we had rejected her application, considering that her husband was continuing as a partner there. We have not rejected after 2019, brothers.
Right.
I may be pardoned.
What was your rejection order date, sir?
Yes, rejection order date. He has challenged it. He had filed an affidavit on 11/12/2014.
No. Your show cause notice was 22/12/2018.
Yes, Milords.
And your rejection order, termination order was 17/5/21.
Yes, Milords, 21.
And she did not get a stay in the pendency of the writ petition.
No.
No, in fact, my lord, I may clarify. In fact, they have
There was an earlier order. So no, 1 minute. The earlier order was 22nd December 2018.
Yes, my lord.
So since 2018 December,
My lord.
this retail outlet is shut.
No, this retail itself was running through another person.
How?
They had allotted another.
They may have allotted. As far as you're concerned,
Yes.
He was not running.
I was not running. I have.
See, your sense with your, that is meaning your husband's severance with the retail outlet, that happened only when the writ petition, that stay order is vacated.
Yes, my lord.
Otherwise, he was still connected with that earlier retail outlet.
No, my lord, that writ petition be called for. I have given an affidavit in that. But even IOCL themselves has offered me also dealership. When this advertisement came, my lord, in 2014, there was 2 advertisements for IOCL and for this.
So BPCL, you applied for BPCL, your husband applied for IOCL.
I applied for both. I am saying, my lord, I applied for both. And both I got, my lord. I left IOCL and chose, my lord, BPCL.
So between husband and wife, you told your husband, I
have left total. That IOCL dealership was at Bhubaneswar, near Bhubaneswar.
This is the whole problem, sir. Therefore, they say one family cannot monopolize like this. You have to have a declaration saying no relation of mine is having any other retail outlet.
Yes,
this is the whole idea. That on your own showing now, it's clear that both of you wanted to have one each.
I have no dealership at all. My husband has no dealership at all.
How do you say?
Your lordship, if your lordship calls for that writ application, disposed of writ application, your lordship will find, my lord, in fact, he has partners. They had also intervened in that. And that is the reason why his dealership was cancelled. Without intimating the, my lord, IOCL.
No, but all
he has taken
cancellation. No, your difficulty is this. That cancellation was put on hold because of an interim order in that writ petition.
Yes, my lord. But my partnership.
No, and you wanted to take advantage of the interim order. You filed an intervention application. You said, how come this is being maintained without my participation?
Why I'll explain.
You want to have a hand in everything.
No. I was not my lord. Your lordship may imagine, my lord, I have left that. That partnership was at will. At will partnership.
Why would you file that? If you wanted to sever your ties with that partnership, why did you file that intervention application?
I'm coming to that, my lord. Why I filed, my lord? Because at first, my lord, when they received the complaint, they kept my LOI kept in abeyance. I gave a show cause. Thereafter, they say that after this disposal of this writ application, we can only give you the dealership. Therefore, my lord, I intervene in that writ application, my lord. And I tried to, my lord.
This I is getting confused.
But I am no more part.
1 minute, this I is confused. Here, when you say I, you are the wife.
Sorry, sir. Sorry, I am extremely.
No, it's a Freudian slip, sir. There's a whole problem.
My husband, my lord. My husband. I stand corrected, my lord.
There is no letter of assurance that after it is disposed of, we will give them. There is nothing like that in the no letter of assurance. Maybe somebody.
Your lordship may finally hear it. I'll prepare a total note. My lord, your lordship may finally hear it.
Let them have an ad hoc running. So let this not go to junk.
Yeah, why not, my lord?
It will be without prejudice to your rights and contentions. It will be without prejudice to your rights and contentions.
Yes, your lordship fix a date then for hearing.
Yeah,
I can pray that.
12997 of 2022. This application by Bharat Petroleum Corporation Limited, bracket BPCL, bracket the appellant, seeks permission to operate the retail outlet located at Bolangir town on Palace Road on NH 26 through an ad hoc dealer till disposal of the writ appeal. Paragraph, this court has heard the submissions of Mr. Shaktidhar Das, Learned Senior Counsel for BPCL, and Mr. J. Pal, Learned Counsel appearing for the respondent. Full stop. Admittedly, the petrol pump in question lying unused for nearly 4 years now, and the equipment there is being reduced to junk as a result thereof. It is pointed out that BPCL has already invested about 1 crore in developing it, and non-operation of the retail outlet is causing heavy loss. Full stop. Mr. Pal states that he would like to file a detailed note in the main writ appeal for it to be heard finally. Full stop. In that view of the matter, it is that during the pendency of the present writ appeal, BPCL will be permitted to revive the operation of the RO in question through any other ad hoc dealer, which would be without prejudice to the rights and contentions of the respondent. Full stop. The application is disposed of in the main writ appeal at the request of Mr. Pal, who wants to file a retail note with an advance copy to learned senior counsel for the.
It was fixed to 18th of October.
List on 18th October, date already fixed. All right. 20th October.
20th.
Right. All right.
Item number 60.
60 and 61 both are similar matter, Your Lordships. This very lucid judgment is at page 82, Your Lordships.
Before my friend starts,
May I please? May I know?
I have the instruction to appear for the.
You would appear only. You would appear only if.
Appear and assist the court.
Let him set out what the matter is about.
It's admitted that your question of appearance comes. Your Lordships will see that this is actually concerning 10 posts of junior clerk. And Your Lordships, only 7 people are there today. 3 posts definitely are vacant from the day itself that this recruitment took place. The issue which arose over here is after we were admitted, after we joined, almost after a year, the evaluation, we found that the evaluation was not done correctly and they came up with a revised list. And that's the point when they wanted to terminate us. We went to the tribunal protecting ourselves. There were 3 people, one of them is Representative Mr. Das, who said that they should be offered the appointment on the basis of the re-evaluation. And finally, the findings are at page 118 of the judgment. I shall be allowed to place it, Your Lordships. The impugned order dated 20 June 2015 and notice of 29 June 2000 hereby quashed, which were throwing us out of job. The selection committee headed by the collector Jagat Singh Pur shall convene a meeting at the committee within 2 months to consider the revised list submitted by the board. A fresh list of revised result forwarded by the board shall be published. All persons who are found eligible as per the revised list shall be offered appointment. In case any of the original appointees is also found to be qualified in the fresh select list, he shall be allowed to continue. Then it's about the seniority, Your Lordships. I just have a very small submission, not really quarreling with the findings of the judgments, unless I have to say something else. Is that, Your Lordships, admittedly only 3 people came up. One of them I know is working as ASO in the Legislative Assembly, which is much more lucrative than this particular job. And 2 more people are there. There are 3 posts. They can be manned. We've actually worked now for 9 years. I mean, at this stage, we'll be thrown out and nobody else has come up really. And I think the others also must be gainfully employed by this time. I'll have this small submission.
The impugned order dated 20th June 2015 removing you has been quashed.
Yes, Your Lordships. No, it has been quashed. But then they have said that, you publish the revised list. In case we are there, we remain. And in case we are not there...
So you're not there in the revised list?
We most likely, I think 1 or 2 of them are there, but almost I think in the revised list, our names are not there.
No, the revised list has been published?
Revised list was produced in the court, not published.
No. So this order is still not implemented.
Lordships, yes. It's not implemented. We've come, it's...
No, because the meeting is to be convened within 2 months, it says.
That's not been done.
Obviously, there's still time.
Still time, Your Lordships.
Then why have you rushed here already?
I know you rushed here already because on this, if this is implemented and they had produced the list before the court and we know that we don't stand. In case... Apart from these opposite parties, if somebody else turns up, you would be thrown out of the job. The question is, the court find that we were not at fault. Our appointment was not because of our any fault.
No, but this is like all those cases of where a re-examination is held.
Yes, after a year.
There is unfair means adopted by some.
No.
The whole examination.
It's unfair means. They had 4 booklets of question papers. What happened during the correction, the key answers which were supplied to the examiners, that was wrong. So that is what they found. So that was the reason of there was a mistake on part of the examiners, not on the part of be candidates.
No, but then your answers are accordingly then evaluated.
There is no dispute about it, Your Lordship.
Then?
That's what I'm saying. There are 3 posts left, and these 3 candidates are the only one.
But you're not qualified. You're not qualified. That's a question of being accommodated.
Lordships, no, we are there within that. We are there within the zone, but within 27 people. But the posts are 10. That's the whole thing.
Therefore,
but one of the candidates, anyways, Your Lordships, is
no. Is there a waitlist system at all?
It's not like that. In fact, a select list was prepared. On the basis of the select list, we were appointed. An appointment letter was issued on 1/7/2014.
No, but there's no estoppel, sir. There's no estoppel. The question is, if the answer keys were wrong, you have to apply the correct answer keys and re-evaluate.
So that is the question, sir. But I have given a copy of the judgment of 2013 Supreme Court. Let's look to that judgment. Kindly come to para 18. Exactly the same. Admittedly, the petitioner have no fault at all. That is also there.
Not a fault, sir. There's no question of fault. If you've given a wrong answer, you get no marks. If you given correct answer, you get a mark.
You'll also look to that.
Of no fault.
That's right. You'll also look to that para 18 judgment. It brought to our notice that in view of the interim
that's all. Because interim orders continued for more than 3 years.
Here we have continued for more than 8 years. We have continued for more than 8 years. We have got also promotion in the meantime. And we are continuing. It also just come to page para 20, the ultimate conclusion of the Supreme Court, which has been followed in 2021. Page para 20, middle, it is also settled down that a person appointed erroneously on a post must not reap the benefit of wrongful appointment, jeopardizing the interest of the meritorious and worthy candidate. However, in cases where a wrongful or irregular appointment is made without any mistake on the part of appointees, and upon discovery of such error or irregularity, the appointee is terminated. This court has taken a sympathetic view in the light of various factors, including the bona fide of the candidate in such appointment and the length of service of the candidate after such appointment. Then you also kindly look to the last para 26, 26. In our considered view, the appellate have successfully undergone the training.
No, but you also agree that only 3 people are affected.
Sir, only 2 people. Sir,
only 3 people have come up. One of them is already working in Legislative Assembly. So only 2 people have to be accommodated.
That is also admitted.
So it will not affect Mr. Das's claim.
No,
Mr. Das can be accommodated. Can be accommodated.
You must make it clear.
May I have the submission?
How many people do you represent?
Only one, and he's the only person who can be selected. At least for me.
No, if there are vacancies where all of you can be there.
The court has taken care of them. What the court has, Honorable Single Judge has held is, let the publication of the fresh merit list will be there. And if they are coming within
No, they are not coming, sir. The whole idea is if they are not coming, then what happens?
Yes.
No, but if their answer is correct, if they will take it in positive sense, that yes, all are will accommodated. Let them where they are afraid of. Let there be a publication of the result. What the fault is at paragraph 14 of the judgment, kindly see the fact. Paragraph 14 of the
27 posts lying vacant now.
Finding of the fact at paragraph 14 of the impugned judgment, internal page 18. I don't know what is the running page of the brief. I don't have a brief. I'm just reading my note. Only 2 lines from that, it will be clear. Since the facts, analysis and finding of the judgment, paragraph 14. Since the facts having been narrated in the extenso herein before, the same are not referred to again. It would suffice to only note that the evaluation of the answers by the Board of Secondary Education was seriously flawed to the effect that the set being identical, the answer key also should have been identical for the all 4 sets.
See, the only thing is about equity. These people have been working for 7 years now. They've been working for 7 years.
8 years.
8 years. All right.
By virtue of an interim order only.
What I was saying, that's what this judgment says. By interim order, they've been working. No, as long as you are not going to be affected, you cannot possibly object.
Yes.
No, if I will be given an, I have not appointed yet.
I know.
Yes.
Only 7 people have been appointed. So 3 is as such also lying vacant.
No, I'm to be.
Yes, sir.
Only 7 were appointed, 10 posts. So 3 years.
Person is the only person suffering right from the beginning. I have been fighting out the liquidation.
Well, let the new merit list as per the revised list, because there is no fetters on the state.
No. How close is publishing that revised list?
No, it's already there. So, my lords, I'll seek instructions, and my lords might call it like post.
You see, there are 2 contentions advanced by counsel for the appellants. One is that among the affected appellants, there are only two persons who are likely to be affected adversely by the impugned order of the learned single judge if a revised select list is to be published, whereas the number of vacancies available are three.
On the very original day. No, not. May the first, Your Lordship, the first page.
I belongs to SCBC. Two persons have been selected as per the old merit list, but my mark is quite high after the revaluation. So if I go to one of the posts, another person will go away.
No, but if you're high in the merit list, you'll go in unreserved category. Yes. You won't eat into the SCBC.
No, I am SCBC. I can only go to the SCBC.
No. If you're high enough in merit, you can go to.
Personally, I verified. I checked up. I only can accommodate it in the SCBC. I cannot go to the otherwise the SC could have been there.
And judgment, I can show Your Lordship. Even the cases.
The chances of the solitary person bracket represented by Mr. Samir Das, learned counsel bracket, who is likely to qualify as a result of the publication of the revised select list. Full stop. Reliance is placed on the judgment in Vikas Pratap Singh versus Chhattisgarh, AIR 2013 SC 3414. And also this Anmol Tiwari.
Yes. That has been followed.
And also Anmol Kumar Tiwari versus State of Jharkhand, AIR 2021 SC 1139. In support of that contention. Full stop. It is further pointed out that the affected persons, that is the appellants herein, have worked for more than 8 years as junior clerks.
And have been promoted also.
And have also been promoted in the meanwhile.
To the senior clerk.
Notice, Mr. Mohanty accepts notice for the state. It is opposite party. Respondent number 124. Das accepts for respondent number 5. Yeah, Vijay Kumar Parida. That's right.
In the
Respondent
first
number
case. In the first case.
In writ appeal 1255 of 2022. Right. Then what about the others? The same thing.
Same.
In 62, it's number 5.
In 60, each one of the respondents.
How come there are so many writ appeals?
Seven of them, all of them had filed separate writs. So to avoid any technical.
I see. So notice, and then he accepts notice. You see, the revised select list if will be that is to be published will be in a sealed cover.
Yes, ma'am.
We'll keep
Sealed
there.
cover.
Because once it will be published, the others will now come forward. There will only
Yes,
unless
ma'am.
there's
Let it be in sealed cover.
So in that event, the task client is concerned.
Publish and give an appointment.
No, they can keep it in sealed cover and hand it over to Your Lordship, and Your Lordship.
If it is sealed cover, then I'm very happy. Again,
My lords may
keep it further in a sealed cover or anything will pass, my lord.
No, it will be here. It will be produced.
Here, my lord, but ultimately, if the authorities will be.
The matter is pending here, sir. So it will be subject to the outcome of the writ appeal.
My lords may clarify that the revised list, if already prepared, my lords, because
now.
my lords, for that, my lords, 2 months have been given. So.
I know, but you can prepare it. We'll have it within that 2 months. You see, the revised list we prepared in terms of the impugned judgment of the learned single judge, but shall be kept in a sealed cover and produced in the court on the next date. List on. We'll have it in November then.
Yes, my lords.
2nd November.
Yes.
There's nothing going to happen, sir. They're going to produce in a sealed cover. So.
Madam Clerk, copies of their. So that
We'll serve the.
Hot.
Judgment CRL REV 655 of 2005.
While upholding the conviction, the sentence has been confined to the period undergone, but the default fine and default sentence has been confirmed. The revision is disposed of. The fine amount should be paid within a period of 4 weeks.
Pardon, my lord, item 38, I was
Supplementary list item number 63.
May I please, your lordship? In the given case, my lord, the petitioner challenges the arbitrary action of the Rawalpindi Development Authority by the annex, whereby it has invited 46 numbers of left out plots in civil township area.
Sorry, what does it say?
My lord, the annex 1 at page number 27, issued by the Rawalpindi Development Authority.
Auction sale of residential left out plots.
My lord, the sole grievance of the petitioner in the case attend that there is a scarcity of land, and he should.
But this last date for this application is 30th July.
My lord, there is a stay in the connected matter, my lord.
By whom? Who's the connected matter?
The connected
I am in the connected matter, my lord. It was posted to 27 January.
Okay.
And direction was given to file the regender in the meantime.
Okay.
That's how the case is. And inquiry is going on.
Let it go.
Yes,
Come
yes.
along that
Yes.
list on 27 January.
Yes, sir.
2023, the date already fixed.
As your lordship pleases.
All right. Both matters.
Item 64.
Item 64, my lords, I may be permitted to appear through VC. May I please your lordships? My lords, here I have challenged my illegal settlement of Chiroli sand quarry, my lords, in the Jharkhand Tahsil of Bargarh district, my lords.
Anyway, your representation is there. Have you?
My
Is there proof of submission of the representation, sir?
My lords, we have submitted the representation physically, my lords.
No.
We went to the office.
No. That's not acceptable, sir. Without any acknowledgement, there is nothing like that. You
My
said-
lords, may I kindly,
Yeah, you
kindly
make a
give
fresh
me some
representation.
time?
Yeah,
My lords,
permitting
may
the
kindly give me
petitioner to
some
make a
time?
fresh representation. And after following up with such representation to seek appropriate remedies in accordance with law, the petitioner.
My lords, may kindly, I request your lordships, my lords, may kindly adjourn. I'll obtain instructions if there is some proof of.
No. We're not
my
wasting time.
65.
65, my lord. Also same prayer. As because representation under annexure 6 series, though it was submitted through post, but postal receipt has not been filed.
So same order.
Your lordship may kindly give me 3 days time. I will file the. Your lordship may adjourn the same, and that is with the petitioner. I will file the receipt.
All right. At the request of counsel, the petitioner list on 19th October.
Okay.
Item 66.
66 lordship, the prayer also they consider the repentation under answer 4 lordship. They have received the repentation lordship with his seal and signature lordship. The
Where is
repentation-
that? Okay. The petitioner's representation action 4 series shall be examined by the opposite party number.
2 and 3 lordship.
Can't be both, sir. Collector and sub-collector both can't sit together.
Well,
By the collector, Bargarh, bracket opposite part 3. And after notice to the petitioners and opposite party number 6, and after giving them a hearing, a reasoned order shall be passed thereon not later than 9 January 2023, be made available to the parties within a week thereafter. The court clarifies it has not expressed in the matter.
Item 67.
67 matters, PIL matters. Every year matters in the eve of matters Durga Puja. Matters we celebrate this on the organization celebrates one Ravana. This is in the bank of that Mahanadi River, commonly known as matters Lower Balijatra Padiya. And let's kind of a glance to that earlier. My last order matters I have given another copy of the order last year. That permission was granted.
What is instruction?
Yes, actually, what has happened, my lords? Every year permission was granted. It was this year. What is the development? There is an NGT order. NGT has directed us to hold the Bali Jatra over the particular area where he wants to, but and to with the condition that we will maintain sanitation and hygiene.
Yes,
he wants to operate that over the Bali Jatra area. It is a vacant land, but since there is a NGT order, so we are. If you're not direct, we'll give the
You consider, sir, with the same restrictions you can permit him.
Yes, that your lordship may.
We'll abide by all instruction matters that
all right.
whatever
The petitioner states that the petitioners will scrupulously abide by all conditions that may be imposed for the purposes of holding the Ravan Podi Utsava on 5th October 2022. In view of the above assurance, counsel for the learned additional government advocate for the state petitioner's representation. Application for permission will now be considered on merits, and the decision will be conveyed to the petitioner not later than first morning.
Tomorrow, because it is within 2-3 days.
2-3 days and holidays will be there. 5th function, my lords.
By first?
First May.
On or before 5 p.m. on first.
May I pray one thing? Your lordship may observe that after complying the conditions imposed by the entity.
Yes, my lords.
Whatever conditions. So he says any condition you impose, he'll abide by.
We will be bound by that.
That your lordship.
Yeah, I've said the first sentence is that one. In view of the above assurance, I'm saying that you will consider and communicate the decision not later than 5 p.m. on 1st October.
We'll immediately communicate it. After the order is passed, on the same day, we'll communicate.
That's right, but not later than 5 p.m. on 1st October.
First.
The petition is disposed of.
Item 68.
May I please enough. My lord, in this case, petitioner challenge the order dated 11/12/2021 passed in the CMPL number 116 by 2021 passed by
So
the
many
Honorable
defects, sir.
Single Judge. Not
So many defects. You
my
remove the
lord,
defects.
defect office not remove defect because the stamp voter mentioned the WA not maintainable against the CMPL order, my lord. But
No, but 4B, 6B, 9, 1, 2, 3, 4, 5, all so many defects.
but a stamp voter office says if
Just examine.
readability is maintainable.
No, you first
I'm trying to
remove the
put it in.
defects. It's not on maintainable. Defects be removed within a week list thereafter.
Item 69.
There is no delay, my lord.
All right. The delay is disposed of. Dispensing with file certified copy review.
Page 62 is impugned order.
But I'm appealing for the respondent.
Page 62 is the impugned order. Direction has been given to give him promotion during pendency of the criminal case. Already similar.
96 is initiated proceeding. 2006 charge sheet filed. As on date, proceeding is not concluded, not progressing.
But
therefore, now the law is also in such a circumstances, minimum ad hoc promotion should be given. Lordship can similar. The division bench have given the order. Similar matter, the division bench has to pass an interim order. Have given the order.
All these matters on 28.
28. And your lordship may see the page 62. This is the first day disposal. Your lordship can dispose of it.
96 initiation, 2006
No, but
charge
on the
sheet
very
filed.
first day, no counter file, nothing, sir.
But due 26 years have not been promoted.
Everything
But there
all
must be a
judges
chance
have
to
been
file
promoted.
counter affidavit at least. There must be a chance to file at least counter affidavit.
That's true, but fact remains. No counter cannot develop more than the facts which are available on record.
No, how do you know?
Yes. 96 admitted.
No.
Materials on record.
If you're agreeable, we send it back or we'll take it on 28th.
All right.
Yes. All right. List on 28th. Notice, he accepts notice. List on 28th October 2022 till the next date, the impugned order shall remain state. All right.
Item number 70.
May I please? Impugned order is at page 53. This is the consequence of the order at page 55. Two appeals are there. Facts of this case, my lord, very short point, my lord. He was initially appointed on DLR basis in the year 1995. In 2012, he has been regularized. The new pension rules came into force from 1/1/2005. Honorable Single Judge had directed him, even if he has appointed on DLR basis, to bring him to the fold of old pension scheme. He cannot be brought under the old pension scheme as he has been regular after 1/1/2005. This is the short question.
May I please your lordship? Similar matter was listed on 12/9/2022, SL number 66. Your lordship has issued notice.
All right. Notice list along with WE number
864/2022.
864/22. When is that coming up? You must be aware, Mr. Kutia.
Yes, my lord, this for 3rd November. And here, my lord, they have filed a contempt, my lord.
On 3rd November till the next date, no further proceedings. The impugned order shall remain state. Both matters.
Both matters are same. Two matters are there.
19 December is this.
Well,
19 December. Both matters.
Item number 71.
May I please, Your Lordship? The IF for bail, Your Lordship.
Why don't you argue the main matter, sir?
My Lord.
Why didn't you argue the main matter? Paper books are ready.
2 days back, I have received the paper book, Your Lordship.
When will you argue? We'll fix a date, you argue.
Lordship, you consider the bail application.
So if you're ready to argue, appeal
Not
itself can
ready
be
for
done, sir.
argument, Lordship.
Appeal itself can be over. It won't take more than 10 minutes.
After vacation only date, Your Lordship.
All right. Since the paper books are ready, the appeal itself can be heard. Consider the appellant states that he will argue it on the next date. 27th October.
Item 72.
So I will pardon the client's mind. So I have an issue lordship. So here lordship, say application for bail lordship. The appellant who is in custody. They're about 11 years lordship.
11 years?
Yes, lordship. Because he's in.
Are there connected appeals?
No. One for single accused minor, the single appellant here. So one appeal also.
11 years? His age is 23, you put?
Lordship, that is criminal appeal number 924 of 2019, Lordship.
Come to the cause title, sir.
Yes.
What age?
Tubu alias Anil Kumar Swai. So at that time he was 23 years, Lordship.
Which is that time? You are filing it 2019.
Yes, sir. Because this judgment was, Lordship.
Please, sir. At least you should change the age at least.
Yes, that's sorry. Excuse.
What are the instructions?
Plus, I don't have any instruction. I'll take instruction.
No. 11 years he's in custody means what?
So because this appeal was filed in delayed also.
No, my land friend should serve the copies of the depositions. I don't have. In the meantime, I'll take instruction.
We had instructions to appear in this case, and we were supposed to file wakalatnama in 2 days. We had instructions for appearing in
He's
this.
appearing now, Mr. Dada?
So I'm the appellant also.
For the appellant, we had instructions.
Whom are you appearing? Who is he appearing for, sir?
His name is there. We had instructions that to appear in here and to say that like we need 2 days time to file our wakalatnama, and this matter will be listed after back.
Then who is he appearing for?
He is already the counsel, but we have instruction that the brief will be transferred to us.
Lordships. So also I have no objection, Lordships. Yes, sir.
All right.
If yes.
At the request of
Client is not
counsel,
agree
the
for
appellant.
Yes, sir.
You say counsel of the state needs time for instructions on the. Just put down IA number 1989.
Yes, Lord.
Yes.
No.
1988.
1988 of 2019. Counsel for the state seeks time for instructions. List on 26th October.
After Puja
Item 73.
73, I am for Kotak Municipal Corporation. They have been already settled and everything is set and done.
All right. Counsel
Nothing
to the
remains.
petitioners. You're
the opposite party. CDM.
None appears to the petitioners. Dismiss for non-prosecution.
I'm for opposite party number 4, my lords.
Item
All three matters.
I am for OP3.
All right. Put down all their appearances.
Item number 74.
74, my lord, it's a PIL matter. The government is to give an additional affidavit. They have not yet given that. Last time they assured to file a additional affidavit to comply. Actually, they assured to establish, to take all possible steps for the establishment of vocational training center of physically handicapped and also VTC, vocational training center at Barang.
You took time, Mr. Monty.
Yes, the status report is in my. I have received the Parave's comment. May I be permitted to file the status report along with the counter affidavit?
All right. Last opportunity to file the counter affidavit before 1st November. List on 17 November.
75.
Please, Your Lordship. My Lord, in item 75, on the last occasion, Your Lordship directed the London Council for the State to obtain instruction in the matter as to how the government land, which is a road, can be settled in favor of a person, even though it is already cancelled.
Present status of the land.
Yes, Your Lordship.
Yes, my lord. What's me kindly pass over 75. Kindly pass over. Let me. The file is not traceable.
ROR still stands in the name of opposite party number 5.
My lord.
Yes, yes, sir. 75.
Pass over.
Your Lordship, they have got it, Your Lordship. 75.
Pass over. Item 76.
My lord.
My lord, 75.
75,
I have
Your
asked for
Lordship.
instruction. I have asked for instruction. It is not. Let it be there on the same date.
All right. At the request of Mr. D.K. Manthi, list on 27th. All right.
Item 76.
76, we are the appellant, my lord. Can it be after vacation? I don't know, ready, my lord.
At the request of Mr. Party, list on 14 December.
Item 77.
Lordship 77, in Kamala Lordship's direction, they have filed a counter. And page 19, para 3, they have stated they have almost completed the work, and Lordship 95% of drainage they have completed. And so far the road work is concerned, the work is going on, Lordship. They have filed an affidavit. With such observation can be disposed, Lordship.
All right. In view of the counter affidavit filed by the NHAI, giving the current status, where is the counter affidavit? Okay. When did you file it, sir?
My lord, I have filed on
22/9. 22nd.
It's not there. The counter affidavit of NHAI will be brought in record. In view of the statement made in the counter affidavit regarding the current status of construction of the highway in question. No further directions. The petition is disposed. All right.
Yes. Item number 78.
78.
78, Your Lordship, may kindly you please to peruse the last order.
Yes, I have filed affidavit on 19th July.
And pursuant to the said order, the state has filed an affidavit that is on board, Your Lordship. And the relevant portion is para 3. They have indicated in detail that the time they required for the widening of the road, my lord. Lordship, may I be permitted to place it for a moment, Your Lordship?
Yes.
Para 2 of the additional affidavit dated 19/7/20 pursuant to the order dated 19/7/22, that in compliance with the order dated 19/7/22, this affidavit is being filed giving the timetable within which the work will be completed, my lord. That it is submitted that the procurement of required private land for widening of State Highway 30 from 41 to 2.
1 year. From 1 year from the date of the agreement, will complete.
My lord. And the relevant portion is, my lord, but straight away come to page number 3. The first para, the last
record
one.
this and dispose it off.
May I pardon? I am for the intervenor petition filed this today, my lord. We are the local person. Now the authority going to demolish our house without complying the.
That is a separate cause of action. They may go for separate.
They undertake that the widening may be completed 30 May 2024. Let it be taken on record and it can be disposed of.
Affidavit of the opposite parties filed on 20th September 2022 sets out in para 4 the detailed schedule by which the work will be completed. In view of the set time schedule, which should be strictly adhered to by the opposite parties. No further directions are called for. The petition is discussed. You file a separate petition, just give that.
We're deeply grateful, Your Lordship. By
Supplementary
virtue of
item
this, the last
79.
part of people will be highly obliged to Your Lordships. So grateful.
Item 79.
Item 79, my lord. I'm for the petitioner. Lord, I pray to file a rejoinder within the course of the week, my lord.
All right, rejoinder will file for the next date. It's on 30th November.
Item number.
May it please, my lords. The judgment of, my lords, the Honorable Single Judge is assailed here in this writ appeal, my lords. The fact is, my lords, these petitioners, my lords, they were applicants for license under the 2007 guidelines issued under Rule 8D of the Ancient Monuments, my lords, Act.
this, and they were also given registration identity cards by the Orissa, my lords, tourism department. These people are eking out their living by taking photographs in the Konarak temple, professional photograph, and earning their money. Tourists, they come, any tourist who comes, these people, they take their photographs and they, whatever, 150 rupees or whatever they charge, they eke out a living through that. And they have been doing it from 1983-84 onward. Continuously, they have been doing it. By now, they have put in more than 30 years in this. And that is their only
some license, some permission, what?
License. The application, 2007, the guideline comes, then you have to now apply for licenses under the Central Act. And these people, they duly apply for the license. Now, these applications were kept pending. They were not disposed of by the authorities. Whether to get or not to get would have been only the applications were considered one way or the other. So that consideration was not made. It was kept pending. In the meantime, the tourism department also issued them admit cards for entry into into this Konarak temple premises, my lords. Now, the point for your lordship determination, my lords, which has been completely missed by the honorable single judge, is this, my lords. Your lordship may kindly turn to page 27. This is the qualification required under the 2007 rules, policy, my lords. Any photographer, my lords, I have put it in bold. Any photographer who is a citizen of India and not below 18 years of age and possesses the requisite skill and expertise to operate a still camera shall be eligible to apply for a license for photography. The applicant for the license need not necessarily own a studio. So this was, my lords, policy was meant specially for these applicants who are there, my lords, without a mobile photographers, my lords, to regulate them. But this was qualification. Now, 2017, all the while 2007, the applications were kept pending. 2017, a new set of guidelines come under that same Rule 8D, which, my lords, there's a change in the eligibility requirement. That is why these petitioners have been heard. Page 29 of the appeal, my lords, petition. Again, my lords, in bold, eligibility conditions. Educational qualifications, matric / 10th pass, and 1-year diploma in photography, or 5 years experience in photography at tourist places. Now, experience is something which they recognize and they give due weightage, and these people have more than 30 years of experience, my lords. So this, while innocuously they have introduced that matriculation, my lord, that certificate.
What does the single judge say, sir?
Single judge did not take, absolutely, my lords, he has the entire order sheet. He has nowhere considered this grievance. He says in paragraph 4, it's a short and cryptic order. Issuance of license for the purposes of license being permitted, page 4, paragraph 4 at page 68. Issuance of license for purposes of license being permitted to take photos to protected monuments is an administrative affair. Though petitioners had applied for license under the old guidelines, their applications were not dealt with. Issuance of license being an administrative matter, there cannot be a direction for issuing license under the old guidelines when new guidelines are in place. In any event, the new guidelines also provide regarding renewal of license, obviously including those licenses issued under the old guidelines. Therefore, even if petitioners got license under the old guidelines, they would have had to come up for renewal under the 2017 guidelines. Now, while holding such, my lords, the honorable single judge proceeds completely on a tangent and, my lords, misses the main point here. Point is, by innocuously introducing...
Which page is the single judge?
Single judge, my lords, page starts at page 67. Page 68 is the relevant portion, my lords. Page 67, that is, my lords, the third annexure.
5/1/22.
My lords, 5/1/22. Order. Your lordship, my lord, the relevant portion is at paragraph 4, page 68. He proceeds completely on a tangent, thereby missing the main grievance of the petitioner. Is how can more than 150 families, my lord, they are now, as a direct consequence, my lord, they are starving on the streets. And then under the new act, a set of interveners, they have intervened. Only 10 persons have been given license under the 2017 rules. And they're all, my lords, age around 40. We are much senior. When we were taking photographs, these people were not even in existence.
Whom are you for, sir?
My lord. Since my learned senior is stating few lines for the interveners, I am appearing for the interveners. We are the licensee.
And we are not after their jobs.
Just one line.
There is no conflict.
Your lordship is some complete confusion in my learned senior's mind. The annexure 1, which was before the learned single judge, it was for 3 years only. Your lordship kindly find only 7 clauses are typed out, and the 8th clause is it was meant for 3 years only. It was an advertisement to apply under Rule 8D. Your lordship kindly find page 28. My learned senior has only typed out the 7 clauses. 8th has been left. I say it is intentionally left because that was the clause. It was meant for 3 years only, and it was for the year 2007.
No, so, but you allowed them to continue, sir.
My lord, my learned senior.
Bread and butter. My learned
but you allow them to continue like this for 20 years and more.
30, all India 30 years. My learned senior, Mr. Padhi, is appearing for the ASI.
My lord, I am for the ASI.
We are the licensee.
Petitioner obtained the license, obtained the interim order by stating for the court that he has obtained a license from the state government. In our
not state
counter affidavit, I have annexed at page 17, specifically state government stated that he has not issued any license to anybody.
So how are they continuing for 30 years then?
My lord, may I clarify one thing? It is a place where they have missed the chance. In 2017, new guideline came. They never applied. They waited for 2007 decision. It was for 3 years only, my lord. That was there before before the honorable single judge. And another thing, we have also filed another writ petition which has never been challenged, which is analogously hard. And my learned senior's clients is well aware. There, I have filed that order before my lord in my objection.
My objection is who is he?
My lord,
I am not after his job. He has no quarrel with me. Only 8. He is appearing for only 8 persons. He wants to monopolize the entire thing.
Mr. Dash.
Only 8 persons.
I'm for the license.
And he wants to monopolize
the new guideline, my lord.
Ensure that we start to death.
Guideline, it was never challenged.
No, are you a party here, sir?
No, he has intervened. I have no cause against him.
Because, my lord,
we have absolutely no cause. I am Mr. Mishra, my lord, the central government.
Enter into the premises, my lord. Despite we have appeared in 3 times examination basis, and
who have been granted license under the 17 rules.
After paying
now they want to ensure that we are starving, and only they will monopolize this.
No, that is not the fact, sir.
We have been there for. That is the reality.
My learned senior is purely confused.
My lord, for regulating the photography inside the Konark temple, in view of 2017 advertisements were made, and then persons have already been selected. The persons more than 100 persons.
How is matriculation linked to, my lords? What
that is the police station.
That's totally different. I am to take photographs and I need it for procedures. There are suddenly to say only matriculation. Matriculates are capable of taking photographs.
They have never.
All of you speak at the same time. It's not possible to hear, sir. Yes.
Sorry, madam.
You want to file affidavits? Have you already filed affidavits?
Yes, no, I have not filed it. I'll file affidavit to the
I want to reply to this objection by the interveners. IA 2929 of 2022.
My lord, I have filed my objection. Let's kindly have a glance to paragraph 7 of the objection I have filed.
No, but there's an objection filed by the caveators. That is your party, is it? This Akshay Kumar Malik is your.
No, this is not.
Somebody has filed objections to that IA.
This is my objection.
That is his party is Akshay Kumar and 7.
Kindly see paragraph 7 of that.
Who's filed IA number 2929?
I have filed, my lords. I have filed.
To that effect, I will file the objection.
Even the amendments, my lord, they have brought in an amendment which revalidates.
My lord, may I submit? And another group also filed another writ petition recently, and it is also pending for the Honorable Court, my lord.
3 writ petitions.
Group of people are coming.
Who is he, my lord? My only contention here is
the situation is going on.
Who's my learned friend?
To go according to the regulations, rules.
Why is he after our lives? He has got his job license and he let him take his photographs. Why is he interested that we should be?
Because you are not allowing us.
There is no bar to
conduct our business.
Nobody is against each other.
154 persons before your lordships now.
Yes.
Now, apart that, more than persons are there. Therefore, to regulate the photography inside the photograph, Konark table, we have formulated a guideline.
Yes.
In view of the 2017 guideline. Therefore, after advertisement, the present intervener and some other person have applied and only 10% have been selected. Now also another advertisement has been made. Let the petitioners be applied for the fresh guideline.
Fresh guideline, but matriculation be removed. That's all. That bar matriculation innocuously you introduce.
That is a separate cause of action.
That affects the entire lot. 7 accepting 17, 18, the rest of them are gone.
The 17.
And how is managed? My contention is
visitors are 100%, but photographers are 300%.
It is my contention is, my lords, what has for matriculation got what nexus, my lords? Reasonable nexus does it have with the policy guidelines? Your guidelines purpose is to regulate photography. And I've been doing it for 30 years. Now suddenly you come up with a stand that only matriculates can take better photographs. Only somebody, as if photography is a course in matriculation. And this is a question of livelihood. We have been suddenly thrown out to the wolves after 30 years. 150 families now, they are starving, facing starvation, my lords.
If my lord permits me for 1 minute, I can clarify. This is all our policy decision matter, my lord. Settled laws are there. Your lordship quite aware of the.
Court is aware of the law.
The 3 judgments are there. These are all policy decision matter. It is in the year 2017, and it is being implemented in our cases. We have got the license after appearing 3-tier examination, my lord. And these people are allowing us with regard that since we are operating since 30 years, we will not allow you. Therefore, we are before my lord. We have also filed a petition, and in that writ petition, lordship kindly see the para 7. I have quoted that the order passed in our writ petition. The analogous hearing.
Everybody else should be thrown out.
No, that is not the purpose. You have not applied, and some of them, my lord, they have also applied. It is now infructuous also otherwise.
Now I am.
Yes. Some of them have also applied under the new guideline.
They also have their 2007 applications there. They have not been considered under that.
Now, once you accepted the order, how can it be
question of acceptance?
Lordship, kindly see the paragraph.
Question of livelihood.
My objection. I have quoted the order passed in the analogous writ petition, where the honorable single judge said that was never challenged. They have participated in that writ petition, my lord.
How can you now countenance 150 families to starve? And you are getting your bread and butter.
Nobody.
And we have
Learned
nothing
single
against
judge
you.
allowed you to apply under the new guideline. That my learned
Leave it
is
to your
not
lordships,
placing.
my lords.
That my learned is not placing. The learned single judge allowed you to apply under the fresh guideline. It's
Yes, but that matriculation qualification may be, my lords, that matriculation qualification may be diluted for us.
They have not challenged that policy even.
Under the same conditions in 2007.
What was the challenge in your writ petition?
Yes.
Writ petition will challenge that policy. By way of an amendment, we brought in a challenge to that policy, my lords. Consolidated, yes.
Where do you get that you challenge the policy?
My lords, the amendment. This is second prayer as to why the notification issued by the Director General ASI inviting applications from eligible persons for issuance of photographer's license under Annexure 9 and certain instructions conditions shall not be quashed. Annexure 9. Annexure 9 is the new guidelines.
No, that's a notification.
No, new notification, new guideline notifications. Annexure 9 at page 42 that
no, it's one small it's not some paper publication kind of a thing.
It was notified, man. It's a
Even
notification.
clause 8 of that publication is also says.
Yeah, Lordship, kindly, I'll pass on the name. These guidelines have been notified. Second guidelines have been notified.
No, where have you challenged that is supposed?
I've challenged Annexure 9, Manoj, that is the same thing. Annexure 9 is the same thing, Manoj. Exactly the same thing.
The policy I have
where have these guidelines been challenged? Annexure 9 is not these guidelines.
Yes. My lord will get the guideline in my intervention application. I have annexed the guideline.
Annexure 9.
Annexure 9 is ODA, some small
ODA.
It's not the guidelines, sir.
Page 24 of my intervention application. Guideline I have annexed.
This is the translation, Manoj. The page 39 is the translation. The applications are hereby invited from interested candidates who intend to obtain license for photography within the premises of centrally protected monuments in prescribed format as available on the website of Archaeological Survey of India under the link issued under the link issue of license for photography. The last date for receiving the application is 31/8/2017.
This is advertising.
This is where the 17 guidelines have been challenged.
No.
This is just a notice inviting applications.
I have annexed the guideline.
Under the guidelines,
So, my lord will find the guideline.
That is why,
just a minute. I am clarifying. My lord may see the IA number 2929/2022. IA number 2929/2022, which was filed by the Shomendra Bose, wherein a gazette notification was in annexed that was notified on 17/7/2018. Yes.
Right.
This is the modified guidelines which required to what my lord might have inquired into my.
Yes.
It was not challenged till then.
It is not challenged.
Yes, it is not.
Not challenged.
Is notified by gazette notification on 18th.
Also amendment. Lordship, permit me to amend it.
Now this is a writ appeal stage, sir.
The appeal stage, yes.
No. In the writ appeal stage, in the writ appeal manners, in the writ petition itself, as to why the notifications issued by the Director General ASI inviting applications for eligible persons for issuance of photographer license under Annexure 9. This Annexure 9 manners.
It's not the guidelines, sir.
It is not it is the advertisement which alludes to the guidelines.
That's all.
It alludes to the guidelines.
It's not a challenge to the guidelines. In fact, you are saying in this 29229 that you have a vested right to have your application considered under the 2007 guidelines and revalidated under the new guidelines.
Revalidation is what they have brought in by way of amendment.
No, but which means you're not challenging the new guidelines, sir.
Yes.
No, I'm only.
If you don't challenge new guidelines, you're bound by that.
I'm only hurt by that matriculation clause.
No, you have to prayer. You have not challenged the guidelines.
Lordship, can I pray for leave to be granted to challenge the guidelines? Lordship, may record. I'll immediately challenge. It's a question of our livelihood, Manoj. And legally we are entitled to challenge, Manoj. For some Manoj, there was.
He is always free to challenge.
Much water has been flown in the meantime. That was also the point discussed before this learned single judge. Paragraph 1 of the impugned judgment.
Well, I take objection to my exception to my learned friend's submission. How can 8 persons?
It is my duty.
Question of 100 persons and 150 persons.
Sir, it is my duty.
Insisting that 150 persons now they starve to death.
Sir,
that
it is
exactly what is intention in the
to indicate whatever you have left.
Extremely mean manners kind of approach.
Paragraph 1 of the impugned order.
I'm sorry. It's anything but a humanitarian approach that my friend is taking, my lords.
Perhaps my learned senior has misunderstood me. I have brought to the exact whatever.
Reality is before your lordship, broad and clear. The entire thing is laid
Right
out.
now, who's been permitted?
No, that's the.
Because Mr. Pollitt's clients say they are not being permitted.
But who are the
This man
person?
says he's not being permitted.
My lord, who
Are there photographers or no photographers?
My lord, we are the person granted with license.
Interveners
but
are
these
now
persons,
permitted.
They are not allowing us.
He's not being allowed. He's saying he's not being allowed.
No. We have been granted by authority, but they have created hurdles.
No orders. They are
Now therefore we have filed contempt.
Now he's making authority. Who is in the monument then?
Man, we are there, my lord, but these people, 150 people, they are saying since we are operating since last 7 years, even if you got license, we will not allow you to enter into the license.
So who's there in the premises then?
My lord, we have been allowed to enter into, but forcibly they are creating problems.
Blowing hot and cold, my lord. Now the cat is out of the bag.
No.
So how many of you, 10 of you?
My lord, we are the 10 persons. We have been granted
They are
license.
monopolizing the entire place.
No, after appearing.
At the cost of our
that is not, you are not allowing, sir. Sir, since you are
At the
more in
cost of our
number,
livelihood,
even if you do
monopolizing
not
the
have any
entire thing.
license, you are not allowing us. Therefore, we have
What's the factual position? You are for the state.
We have prayed
I am for the ASI, Hercules
I am for the state.
Okay, one of you tell us what is the factual position.
I'll have to take instructions of today, Millers, who is being because as per the 2017 guidelines, pursuant to that, whoever has got license legally, he should be allowed. And
I am clarifying. What happened in this case?
But
my lord, my humble submission is they have obtained a stay order stating that they have issued a photography license from the state government, but state government categorically stated that they have not issued any license in respect of anybody. Now, in view of interim order and the license holder, now operating more than 22 persons, and also we have already in advertise
Which stay order? Which stay order?
That earlier was operating in the read petition.
Petition. That's all over, sir. Now
That is now the issue. My lord and senior stating that they have a valid license since 2007, but they have not issued any license. At no point of time they have issued.
Not a license, it's an identity card. My pleading is there. Direct pleading is there, page 28.
No. The interim order, I am saying, in the interim, it is direct that the petitioners who have been granted license by the tourism department shall be allowed to perform their duties.
Malay, it was on the basis of identity cards.
That was the pleading. The court had allowed you, and then we inquiry and found that the no has been issued by the state government. Now already advertisement is floated.
It is due to
Some of the persons have already been participated in the advertisement.
I'll have to, on a lighter way, I'll have to take
Leading in the
instructions. Who is in the frame? Who is in the
This is your
frame?
policy, right?
Yes, no, Millards, this is an ASI monument. So the union.
Who determines the qualification to be a photographer in Konarak? ASI. Then what is the rational basis for this matriculation?
This is the notification, man. This was the notification. We have come with a proper regulation because prior to that there is no specific.
Sir, somebody who's a photographer in Konarak for the last 25 years.
Yes, my lord.
Suppose he's not a matriculation. Now, after 25 years, because he's not matriculate, you will throw him out.
I'm just clarifying. That's why I'm doing, my lord. I'm giving 2 minutes time. But really, I'm just placing my lord. So many persons are coming and introduce themselves the photographer. Then commit many things and many crimes. Yes. That's why the ASI authority. What does
that mean?
Just a minute. Grandstanding the issue, my lord. My friend is grandstanding.
No. I'm not dilating anything. What really
I'm grandstanding the issue.
What happening? So they have called each other. Then it is a matter come to the authority concerned.
For 25 years, nothing happened. Suddenly, he woke up and found people
that is coming to the state. Then all over India.
No, his grandstanding.
That guideline is not only for the Konark, it is for all the monuments throughout India.
Exactly. It is a uniform policy has been decided by way of notification. Then it was again amended 2018. So all are binding. Whoever may be qualified, they will participate in the process. Regulation will be acted upon. Then only they will obtain like the SI. Then they are allowed to go inside.
We were qualified under the 2007 guidelines. You disqualified us under the 17 guidelines without considering our applications under
they are
7.
claiming that we have got the license from the state. That's why we are allowed. It is not completely wrong, my lord.
My learned friend is taking off.
I cannot confirm your only thing that who are really doing the photograph, they are really on the picture and they are to try to do so. We are ready ours. That's why we are going advertising every after 2 years gap, and they can participate, they can select. They again they have a control and they will issue.
Mr. Party, what will happen is depending on what qualification you prescribe, you can either allow people to come in or exclude people. Like tomorrow, let us say, tomorrow you come out with the policy that all of them should have a BA. Then what happens?
Then my learned friends' clients also go.
My lord,
interveners also out.
I don't go, but minimum qualification is
quite now.
Why give
if it is consistent with photography, you can understand. It's not, the qualification is not consistent with photography.
Yes. I'm telling I'm clarifying. In Konark clerkship knows or any monument places, many outsiders are coming from abroad countries are coming from other side. Minimum qualification record, they can speak, they can all these things.
You mean to say everybody who is matriculate knows to speak?
My lord.
Those who are not matriculate cannot speak. Is that your contention?
It is not issue. It is not. We are deciding a rules and policy decision.
Correct.
At least matriculation qualification.
It has to have a rational nexus, sir.
My lord,
it has to have a rational nexus. Suppose you're testing somebody's skill at speaking, you can test it. If you're testing somebody's skill at photography, you can test it.
No, yes, that is also there. That system, my lord. They are submitting application. What as regard to the matriculation part is concerned, why I am telling, my lord. The policies.
So normally there will be if once you bring a new policy with a new qualification and there are existing people, if you eliminate them from participating policy process, then it is bound to cause difficulty. Then you should say for those who have already been.
I am understanding the program, my lord. I am understanding program, my lord. But
now they are saying
there is no. Otherwise, there is an open gate for everybody. Whoever, even though who has a basic.
No. You make a condition that they should have experience in photography of at least so many years.
Yes.
That's why.
Something. I'm just saying you can easily prescribe a condition that is consistent with the requirement.
When issue is coming from Chennai, there is another issue is going on there. That's why. All over India, all the issues in technical.
Diploma also can be given a go by if you have 5 years experience. New policy.
No, it cannot be policy decision. We cannot take here because it's the education. Because
even diploma, you are willing to compromise.
Minimum 5 years. Why?
That is the weightage you are giving to experience.
At least there is also a provision for my learned seniors client at clause number 7.7. Old licensed photographers, they can be nominee photographers under the license.
Challenge the policy. What Lordship has rightly
yes,
said.
They have never challenged the policy.
They are not challenged the policy.
It has implemented since 2017 throughout India.
All are participating except this group.
Yes, it is implemented since 2017 throughout India.
Yes,
it was never been challenged, my lord. They have missed the boss. Seniors client missed the boss.
Easier said than done. Dear friend, it's a question of life and livelihood.
No, sir.
Easier said than done.
There are certain provisions are available for you at 7.7, sir. Perhaps my learned senior has not gone through that. They
what
can
is 7.7? Okay, what is 7.7?
My lord, 7.7 says old licensed photographer. Let's see, got at page 9 of the my learned seniors IA
2929.
Yes, 7.7 old license. Let's see, get. Old licensed photographer or nominee photographer shall have to pass the test after completion of refresher course, my lord. That was the provision given. They have not availed that, my lord.
And also 7.5. All valid licenses
so my license
prior to 2002
not considered. So
yes,
No, that is for validation of the license. Sir.
Yes.
Those who have valid
Revalidation.
For refresher course for validation. That is after once license is issued, then you want to validate it, you have to pass this course.
Deeply organized.
So if there was a license granted prior to 2012 and you want to validate it, then you can do it. But they don't have a license to start with.
They can
because there was no policy to grant license.
My lord, they can be the nominee photographers under the licenses granted by the SI.
They will take a commission from my.
No, you'll get your.
No, but how many nominees can be there per photographer?
There are number is fixed for 10 under one license.
Each photograph can nominate 6.
There is a clause in that light.
What is that? Which is this clause?
Nominee photographers.
What does that mean?
Number of many photographers under the policy itself in 17 policy that I have annexed to my application.
No, this is a nominee photographer working on the basis of a nomination given by ASI prior to 2012.
Yes.
Yes, my lord.
This is not. No. So they're obviously they cannot be nominees, sir.
We applied under
that system of nomination is over. This is nomination prior to 2012.
We applied under 2007 guideline, which we were qualified. They did not consider our applications. They kept it pending. And then they come up with a new set whereby we are debarred matriculation.
Right.
No question they introduce matric and we are debarred.
These appellants have waited for 8 years. 7 policies were, even if accepting for the sake of argument, my lord, though not admitting, in 7 advertisement was made. And
I think ASI is to come up with some separate policy for this. You will have to come up with a policy for the existing photographers. You don't have to disqualify the persons who have already qualified. Let them also be there. Let these persons.
They have
when
only
you have a cap, you'll say there will be no more from that category.
But here, so far as Konark is concerned,
what is there to show you have been a photographer? Only your pass.
Identity card. Issued by tourism department. Orissa, state of Orissa tourism department.
So that should be the basis for being considered.
That should be the basis. That should be the basis.
And tourism department said we have not allowed anybody.
No, not
in their counter.
Tourism,
it was an identity card issue.
But not in respect of
tourism. License can be issued by the central government, but we have issued.
Konark is concerned, they have not issued. They have issued.
Yes, that is the fact.
These are identification cards issued by the tourism.
To guide the visitors.
You see, there is a serious issue concerning the photographers at Konark. So some of them have been photographers for over 3 decades, but do not have the qualification of being a matriculate, which is required under the policy framed in 2017 by the Archaeological Survey of India, (ASI), for grant of licenses. So as a result, the 154 petitioners who had filed writ petition civil (17384) of 2015 find themselves out of the reckoning in terms of the 2017 policy. Full stop. Paragraph. It must be noted here that earlier there was a policy of 2007 of the ASI in terms of which the said 154 persons would have been eligible to be considered for issuance of licenses. Mr. Palit, and the senior counsel appearing on their behalf, states that although they had applied under the 2007 policy, their applications were never considered and were kept pending by the ASI. And in the meanwhile, the 2017 policy has been framed, imposing a condition which the 154 persons cannot fulfill. Paragraph. Meanwhile, 10 persons who applied under the 2017 policy have been issued licenses and are represented by Mr. Dash on their behalf as interveners. Full stop. He makes a grievance that the 10 persons are not being allowed to function freely in the monument by the 154 persons who have been kept out. Paragraph. The contention on behalf of the ASI is that for all the monuments throughout the country, a uniform policy was framed by the ASI for the purpose of regulating photographers operating therein. Full stop. The fact remains that the 154 persons who have been photographers for over 2 decades and some for nearly 3 decades suddenly are without a livelihood on account of the changed policy of 2017. Paragraph. Mr. Palit states that if there is just one change in the 2017 policy, which will enable those who have been issued identity cards, is it? What have we been issued?
Identity cards.
Identity cards by the Department of Tourism, Government of Orissa, to apply for licenses without insisting on the qualification of matriculation, then the concerns of the 154 photographers would be addressed. Full stop. This appears to be a genuine concern, and it undoubtedly affects their livelihoods. Full stop. In the circumstances, a direction is issued to the ASI to consider the above request of the 154 photographers and examine whether there can be a one-time exception provided to those who may not have a matriculation qualification but have been issued the identity cards by the Department of Tourism, Government of Orissa, to be considered for grant of license, even in terms of the 2017 policy, subject to their qualifying, otherwise meeting the other requirements of that policy. Full stop. An affidavit be filed by the ASI before the next date. Full stop. It is made clear that this policy change, if accepted by the ASI, will not affect those who have already been granted licenses under the 2017 policy.
And that's only one thing, that there is a maximum age limit also in the.
All that, we accept all that.
So some of the petitioners.
He's not asked for anything else.
Some of the petitioners are above that.
Lordship has been extremely gracious, my lord. In the meantime, can we continue, my lord?
That's the whole problem. So you'll have to be more patient. Let them do it in a time-bound manner.
For the last 3 months, we have been starving, my lords. Now the pujas are right. We all have families, children, my lords, mouths to feed.
No, but there'll be chaos there, sir. That's the whole problem.
No. All those who have cards, my lord, issued by the tourism card, they will.
There was a stay in there.
Yes, my lord.
No.
Collector can monitor. Collector can monitor. Whoever is allowed by the collector after scrutiny on the basis of production of evidence that they were photographers can be allowed to perform.
300 to 400 people.
Purely as an interim measure. The collector will scrutinize, my lords, whoever produces the evidence that they were there, my lord, they can be permitted by the collector on regulation.
300 to 400 people will come up again.
Well, there's a tourist officer.
There's a tourist officer.
Whoever,
yes,
the lordship can, whoever.
Number 4. That's that.
He created another problem for us. Creating another problem because now they are fighting each other. Now this coming to the state and ASI will say our
How
people.
soon will the ASI consider this?
My lord, in
You consider it within a month.
Pursuant to interim order passed by single judge, the 5,000 rupees deposit before the concerned authority, and that they are allowed to operate a photography for as per condition for once in a week. That by virtue of
that order can be continued then.
That's such
Where is that interim order?
Yes,
This is a different set of people. Different set of persons.
That is including 5 to 7 read petitions before this.
These are not the petitioner in that.
No, these petitioners are not. The other petitions, in respect of other petitions.
How many persons are there like this?
That is.
Now it will 300 to 400 people will come up.
A drowning man catches to even a straw, my lords, would 1 day or 2 days a week.
How many such persons are there? Because the monument can only hold so many persons.
Yes.
You can't have a.
No, the policy says it is only 80 vacancies.
Monument was holding 150 people.
Only 79 photographers.
Monument was holding 150 people.
Guideline.
So why should it not hold now?
My lord, guideline says only 78 people will be accommodated as photographers. That is there, the Government of India guideline in that Konark monument.
So,
that is there, my lord. So how can 300, 400 people will come up? My lord, we have paid 25,000.
300, 400 people are not before the court. And 300, 400 people are not there.
5 writ petitions are already there.
No, but today the writ appeal is filed by 154.
154.
And
they have also more than
4 writ petitions already interim order continuing.
No. What happened to those writ petitions?
They are, my lord, they are paying 5,000 per month.
So they are continuing.
Minor.
How many of those writ petitions are there?
We have also interviewed
4 writ petitions.
No, how many persons on all?
That they have deposited 25% deposited
persons, sir.
250, near about 250 persons.
Lordship may direct to operate that interim order.
No. In their writ petition, there was no interim order.
No. We have been thrown out.
They have not. No, but this yours was a 2015 writ petition.
My lords, it was initially there.
Initially,
we had got the interim order.
What order? You showed me what interim order you had.
That's part of the record.
In the writ
that they'll be permitted to
in the writ petition
enter
dated 29/8/2017.
That order may be continued.
And that order
again it will lead to chaos.
No, which is the interim order? So I'm not able to find. 29/8/2017.
My lord, there will be a technical problem with that. You will also kindly see in the writ petition, we have approached the Honorable Court. Honorable Single Judge directed in our writ petition, whosoever having a license will be allowed to enter into the monument. That never been challenged. They have participated in that, my lord. They have abided by that.
Where's the question, sir? See,
sir, they have not
license because you are matriculates.
My lord, they have not challenged that. They have accepted that order. Your lordship kindly see that is there. I have annexed in my objection. That writ petition they have participated, my lord.
Participated meaning what?
They have intervened. Their intervention was allowed, and the Honorable Single Judge directed whosoever having a valid license only allowed to enter into the bench. They have not challenged that, my lord. There's a technical problem with that.
No, but they had an interim order in their favor on 29/8/2017 in
it
their
was
own
only for 6 weeks, my lord. That was expired.
No.
Your lordship kindly see. I have annexed to my objection. The 2929 objection I have filed to 2929 IA.
The interim order was continuing. 1 minute, sir. The interim order continued well beyond, sir.
Sir, it was, my lord, with due respect, my lord,
6 months.
it was only for 6 weeks only.
6 weeks. Page 16. Yes.
It is clearly revealed, my lord, in the impugned
So
order.
you've been out since then?
Yes, my lord.
Mr. Palit, you've been out since past 5 years now.
No. We have been out pursuant to this contempt filed by them. They filed a contempt only 3-4 months ago.
Because you have not challenged that order.
4-5 months ago, the Honorable Single Judge directed that the collector.
No, your interim order ended.
No, we were continuing. Because matter was not listed. We were continuing. There was no hindrance in continuance. It was only pursuant to a contempt application filed by my learned friend That the Honorable Single Judge said no, that anybody who doesn't have a license.
Actually, there is an interim order on 30th January 2018 in their writ petition saying the interim order passed earlier shall continue to the disposal of the writ petition.
That is.
So there was an interim order throughout, sir.
My lord, that was ended at the disposal of the writ petition. For 6 weeks it was there, and to that, my lord, they have accepted the order.
This is a writ petition of 2015. It got disposed of in 2022.
My lord, you kindly see the disposal order itself. That is there reflected.
No. The point is that there was an interim order protecting them during the pendency of the writ petition.
Yes, my lord.
So that interim order can continue now, sir.
My lord, that was with the old guideline, my lord. Once they have accepted the new guideline, they have applied. Some of them have also applied under the new guideline. The writ appeal itself is infructuous in the meantime, my lord. They have accepted the new guideline. Some of my learned senior filed affidavit that we have not applied under the new guideline. They have applied, my lord. Some of them. It is otherwise infructuous, my lord. They have accepted the order as a whole.
It appears that during the pendency of writ petition civil 17384 of 2015, an interim order was initially passed on 29 August 2017, stating that petitioners who had been granted license, that's the word license,
yes,
issued by the tourism department, shall be allowed to perform their duties as professional photographers till the next date. Stop. It appears that this order continued throughout the pendency of the writ petition. It is now explained that although the expression used is single quotes license, unquote, what the tourism department issued was in fact an identity card. And admittedly on that basis, the present writ appellants, 154 appellants, were functioning within the monument. Full stop. It is only after the impugned order of the learned single judge passed on.
This is minutes.
5/1/2020. 5/1. 5/1/22.
5/1/2022.
5/1/2022 that they have ceased to operate. Full stop. Paragraph, since it's a question of livelihood, and considering that they have been functioning as photographers even during the pendency of their writ petition, on a balance of convenience, it is directed that subject to the, what officer is he?
That's tourist officer.
Tourist officer.
Konark.
Konark. Regulating the entry of the photographers.
It's a contrary, because the law says it is only the authority of ASI. It is
okay, you have an officer, then let
an officer, and then they are regulating the entry person.
Yes.
To
which officer you tell us?
Yes.
You tell us now. Let the ASI officer regulate it.
Yes, ASI. That is in that order. That is a ASI with this district administration.
All right. Subject to the ASI and the district administration, the entry of the appellants on the basis of the identity card issued by the tourism department, only such of those appellants possessing such cards will be permitted to operate in the monument till further orders from the court.
Obliged.
Lordship, fix up any date.
Urgent copy of your lordship.
List on 21st November.
Obliged.
All right, 21st.
Why
don't you have the other writ petitions brought up or whatever?
Yes.
You're going to have two sets. 4 writ petitions are pending before the single judge.
Yes.
And one set has been out because of the impugned order. You should have clubbed all the writ petitions together.
Yes.
Lordship, pass order.
That already fixed 2010-2022 for hearing all the.
All right. Anyway, this is now fixed after that, 21st November.
Urgent copy.
Our concern is only to regulate, minimize the photographers and nothing to minimize the photographers. Maximum 50 to 60% per day. That your lordship may direct.
You may regulate, then you have them operate. You fix a number. And you
number
rotate
has been fixed. My lord, number has been fixed at 78.
Then let them be rotated, sir. What I'm saying is, And on any given day, there will be not more than so many photographers.
Yes, that
clarify this fact in your
with the number is
It will
fixed
be
to
open
78.
if there is a concern from the side of the ASI as to the maximum number of photographers that can be permitted. Then a system could be devised to limit the number.
That is there in advertisement. That is fixed to 78.
Yeah, and permit the photographers on a rotational basis, right? And permit such number of photographers to operate on a rotational basis.
Without having license. Your Lordship, without having license, because we are the licenses. Then again, they will trap to
Pulling a fast one on your lordships.
My lord already
Pulling
pointed
a
out
fast
that
one
those
on
who
your
have
lordships.
identity cards. My lord,
Yeah, you said this. Yeah, this requirement will apply only to those. Will not apply to those who've been granted regular licenses under the 2017 policy.
Okay.
That's fair enough. Yeah,
That's
correct.
Did you guys?
Right. All right.
Item number 81.
Item 81, my lord.
Lord, in item 81, your lordship may see the last order.
Yes, my lord.
Last order, your lordship directed in two things. To make a publication in the Gazette, my lord, that they have done. They have filed an affidavit.
I have filed an affidavit. My lord, second item may be taken up, my lord. WM 10 by 2022.
Will you please wait? Why you are impatient?
Right.
The second is that your lordship told that time schedule.
Correct.
Now they are, your lordship may say, they earlier filed an affidavit on 21 on 19/7/2022, my lord.
Yes.
Where they told that we require 280 days, but we have decided to do it in within 220 days. Again, now in this affidavit, they say that again we require 220 days, 280 days, and 220 days. But that 220 remains constant, irrespective of the flux of time, you know. Lord, and in this context, Lord,
you must allow me to.
Lord, this matter, Delhi Bar Council matter came up before the Honorable Apex Court, before Justice Rohinton and before Justice B.R. Gavai on 12/7/2021, my lord. May I just read out, my lord? It is similar to that, my lord. As requested, Mr. Vikas Bhattacharya, an advocate on record, is discharged from this case. Mr. Samar Sudhi, Land Council appearing on behalf of the applicant, has informed us that at least 6 months is required for the special committee to complete its task of verification of certificate of advocates. We must remind the committee, and particularly the Advocate General, who heads the committee, that 2 extensions of 6 months each have already been granted by the Bar Council of India for an election which should have been held way back in 2020. The second extension has in fact expired on 2/2/2021. Given these facts, the Advocate General is directed by us as head of the committee together with other committee members to complete the verification process within a period of 3 months from today. So that your lordship also assured me that since it is not an adversarial litigation, that your lordship will curtail down the time. You know. I leave it to your lordship. How can they say that the committee special committee has already taken a resolution on May, my lord?
Because of the delay caused by Bar Council of India, my lord, in this non-practicing list, my lord, your lordship, last order, your lordship has seen. Order, your lordship has noticed that we have received the non-practicing advocate on 22/8/2022. On the very next day, Bar Council has circulated the list to the all Bar Association, to the Registry of the Supreme Court, Registry of the High Court, on 23, very next day, my lord. And thereafter, my lord, for updating the electoral roll, my lord, after on 30th, my lord, 30th of August, my lord, the lordship may turn to page 9 of my affidavit. published the notice under Rule 4 in 2 local newspapers, my lord, one of which in vernacular language. And also, page 11, my lord, we have issued the state government for gazette, publishing it in the gazette, my lord. And last, my lord, your lordship may turn to page 13, where on 19/9/2022, my lord, we have sent the draft preliminary voter list. That means, my lord, by publishing it in the paper, my lord, we have started the process of election, my lord. That is Rule 23, my lord. Rule 23 of the 2016 rules. Last occasion, lordship was told if it has not been gazetted, it should be gazetted in the meantime. That we have published. That gazette notification is Annexure 16, page 21, my lord.
Gazette notification, your lordship directed regarding that electoral rolls to be published.
Preliminary voter list, that we have already said, and we have fixed the date to 20th October 2022. Now your lordship may turn to relevant person, page 27, my lord. Page 28, my lord. 28 of my today's affidavit, chapter 4, my lord.
Yes.
My lord, chapter 4, third para, my lord. After 160 clear days of such publication of notice, the State Bar Council, this, my lord, we require this 160 days. And again, my lord, chapter 5, second time frame for election. This election of the State Bar Council shall be held within 60 days. That's 160 plus 60, 220 days we require, my lord. That I have indicated in my affidavit, time frame for 60. This has been gazetted, my lord. So we want, my lord.
No. The final electoral roll, when will that be published?
My lord, it has not been published, only draft election.
No. What is the date of, now you will know the date of publication of final electoral roll.
We have 160 days, my lord. 160.
No, you tell us the date, sir.
My lord, that date, my lord, 30th August. 30th August 2022, 160 days from that date, my lord.
No, you've asked for mistakes, typographic errors to be submitted before 30th October.
30th October, my lord.
So within 1 week of 30th October, you should be able to come out to the final electoral list.
For that, I will take instruction how much time they require, my lord, for preparation of final electoral list, my lord, because as per
No, once all the objections are to the draft is received by 30th October.
Yes, my lord.
You only have to go through those objections and publish the final list.
No, my lord,
final roll.
My lord, that language is, my lord, 160 clear days of publication of notice. The State Bar Council shall publish the final electoral roll containing the name of those advocates who have not been included in the list of non-practicing advocates under Chapter 6 of the Bar Council of India Certificate and Place of Practice Verification Rule 2015, and who have cleared the welfare amount as required under 40 of Chapter 2 of Part 5-6 of the Bar Council of India rules. And those who have passed All India Bar Examination, this part condition is only applicable to persons who have enrolled after 2000.
No. This the expression is after 160 clear days of publication of notice.
Yes.
This notice was published when?
30th August, my lord.
30th August. So 5 months after that. So that takes you to January.
Yes.
If it takes you to January and then 60 days from then. March. So why are you fixing the date of May? You have said the tentative date of holding is 20th May.
My lord, I'm just clarifying.
160 days, 5 months approximately. By 10 January, it should be enough. days from the date of publication. You say an affidavit has been filed by the Odisha State Bar Council. It's stated that pursuant to the order dated 24th August 2022 of this court, the State Bar Council on
It comes to February 10th.
30th August 2022.
Yes, sir.
Published a form of notice under Rule 4 of the Verification Rules 2015. Further, on 19th September 2022, the State Bar Council has forwarded the draft preliminary voter list to the respective bar associations in the state, with a request to inform it regarding any mistakes or typographical errors on or before 30th October 2022. Paragraph. The requirement under Chapter 4 is that after 160 clear days of publication of notice, which in this case is 30th August 2022, the final electoral roll has to be published. Stop. This approximately works out to 10th January.
10th February, madam. 10th February.
No, September, October, November, December, January. Okay, 10th February.
Yes.
2023. Full stop. Further, in terms of Chapter 5, the election has to be held within 60 days from the date of publication of the final roll. That is 60 days from 10th February 2023.
Yes.
Full stop. A further affidavit be filed by the Bar Council working out the correct schedule of elections on the above basis and be filed before the next date.
Well, the word is within 60 days of the...
That's right. That's right. Within 60. That's why I'm saying let them work out a schedule.
Not for after 60 days.
No. Obviously within, sir. Within.
Conscious of that.
List on 5th December. 5th December.
Note my presence for
But for this intervention, probably the voters list would not been ever finalized, because all elections are being held up throughout India, and wherever election has been held, it has been held on the directive of the Honorable Appeals Court that the existing voter list you conduct the election.
All right.
The general Sangma judgment, that is that word. The title Law and Scenery is saying that judgment.
Right. That's Nariman is governing. All right. Right.
Item 82.
May I please?
It may please your lordship. We have filed Doksatnama for opposite part number 2 and 3. That is Career Cancer Institute, Post-Graduation Institute of Cancer, Kotak. And also we have filed a counter affidavit. A copy has been served on the petitioner. It's our prayer that our Bhinama as well as the counter affidavit may come along with the record.
My lord, I directed to serve a copy on last occasion.
No. Are you going for a fresh selection or not? That's the first question.
Yes, my lord. That I have
annexed. If you're not going for a fresh selection, then no need for interim order.
Flag B, my lord.
No, my lord.
I have annexed
time. There is an advertisement. And that date of that advertisement has been over. Applications have been come, and we are going for fresh selection.
Then you stay it, sir. Then you have to stay it.
And that has not been stayed.
So we will stay it now.
No, my lord, we have already filed the counter affidavit. This is a writ appeal against the judgment of the honorable single judge. And in fact, this writ appeal in essentially another writ petition before this honorable division bench. Although the nomenclature is that it is a writ appeal, but there is nothing that there is any any error apparent in the face of record.
Why?
Because the judgment is quite exhaustive. The question is that the applicant, the appellant, they did not possess.
The way you read the clause is important, sir.
Yes, my lord.
How do you read it? Let's see how you read it.
Yes, my lord. That is the advertisement.
The relevant clause regarding qualification, how do you read it?
That is the advertisement. Annexure. They have also annexed it. Annexed it in the writ appeal.
Even they have solved a copy of the counter where they have annexed the same that guideline which I did so, my lord, but they have annexed the portions which are not relevant. This is the counter affidavit.
It's all right. Let's go to the actual clause. It's discussed in the judgment, sir. Just let's read it from the judgment.
Yes, my lord.
Page 33 of the writ appeal paper book.
Yes, my lord. Yes,
Which page, sir? Why don't you tell me? Last time when you argued, you pointed out to a page.
My lord. That I did so from the my lord note guideline which I did so, my lord. 88 second.
No, don't read petition.
She showed last time. Why is this not done? Just scan this.
That is very interesting. My lord, I want to draw your lordship's attention to the writ petition. That is WPC 27613. Mohanlal Khadia, where is the petitioner? That is the annexure 1. That is the advertisement. Which that is the page number 13 in the writ petition.
Yes.
Writ petition, page number 13.
Yes.
That is the educational qualification and selection criteria.
Yes.
A is for broad specialty. We are not concerned. For super specialty departments, MD/MS plus MCH/DM equal to MCH/DM degree will be preferred. Actually, this super specialization, the faculties are required to teach in MCH. They also man the specialty, super specialty doctors. Thereafter, a relaxation has been given. Those persons who are not having MD, MS plus MCH or DM, a relaxation has been given to them. He/C should have a PG degree in super specialty or PG degree in concerned broad specialty as per MCI with 2 years special training in the concerned super specialty.
So that this special training, sir, with 2 years special training is for people who do not have that PG degree in super specialty. It is for PG degree in concerned broad specialty.
Broad specialty.
So if you have a degree in broad specialty, according to this advertisement, you should have 2 years special training in super specialty.
In this case, the appellant belongs to broad specialty, not super specialty. For that reason, he requires a 2 years training. That too special training in that super specialty subject, that is medical.
He has a degree in surgical oncology or surgery. He has a broad specialty. He is in surgery.
He is in surgery.
And you say surgery plus 2 years training in surgical oncology.
Surgical oncology. To undergo that 2 years.
Whereas if he had a degree in surgical oncology, he does not need training.
Those who have got degree
in surgical oncology,
they don't require any 2 years training. But here, he is a candidate from broad specialty.
What he is referring to, see, let's now look at the compilation is given. Please see this compilation. He says that you have borrowed from Medical Council of India requirement. The MCI requirement is something different. Now come to page 3. For surgical oncology, just come to page 3, sir.
My lord, he participated in the selection process. He applied. He did not challenge the advertisement.
I don't need to. I am eligible as per this.
No, he is not eligible. The question is that the Fourier Cancer Institute is a registered society. It is supposed to follow the guidelines of the MCI and subsequently which has become NMC.
That's what my case is. That's what my case is.
Okay. But that doesn't mean that the strictly what is there will be followed A to Z. The advertisement is there. In the advertisement, we cannot change or moderate the advertisement for a particular candidate. It is not to be interpreted in that line. The question, actually, Medical Council, the MCI guidelines also provides for 2 years.
There differently. That's why just read that page 3. Just read page 3, sir.
NMC guideline, this year also, they have provided this special training for 3 years.
We are concerned about the previous guideline.
No, just read that page 3 for a minute.
Yes, my lord.
You will find a section saying surgical oncology. Page 3.
That is professor.
Correct. He's applied for professor.
No, my lord. That is the requirement for all. Professor, assistant professor, the next page. And assistant professor and associate professor. That is common.
All right.
My lord.
Anyway.
That is in page 5.
No, but it simply says do, sir. So we read from first page, page 3 only. The next pages, it simply says do. DO.
Yes, madam.
So you have to come back to the first page to read.
MCH, surgical oncology,
stroke,
oblique MS surgery, oblique or MS.
So that oblique
MS
orthopedics. So that's the point.
The obstetrics or gynec will with 2 years special training in surgical oncology.
So what he's trying to say is, if you have MCH in surgical oncology or MS in surgery, you do not need 2 years special training. This is his contention.
No, my lord. No, my lord.
No, because the stroke or it says.
No, my lord.
Well, let them show the 2 years special training is available. There is no course available also.
Yes, it is available. It is available. The Honorable Single Judge has also specifically stated where it is available. It's a question of factual analysis.
No, it's not available.
And there is no scope to make a reappraisal of the same. The question is that, and this time also, NMC guidelines provide 3 years special.
This relates to the earlier guideline. But
the question is, there are certain institutions providing. If he says that there is no such provision, he could have challenged at the time of the advertisement when it's floated. He participated. And subsequently, by making a 3 years senior resident in the subject, telling that he has got experience in teachership of that line, cannot substitute, cannot make an alternative to that. The question is, he has got no 2 years special training in surgical oncology.
No.
So,
where do you get special?
Had it been so,
No, 1 minute. Are there institutes offering this special training in surgical oncology?
Yes, my lord.
Which institutes offer that?
In the judgment,
No.
Where in the judgment you tell?
In the judgment,
Tell us.
Single judge has pointed out.
Let us
point it out.
Yes, let's see that.
Judgment. Judgment.
Para 26. Let's read para 26, impugned judgment.
Averments of the petitioners. Should I read him?
Yes, please.
The averments of the petitioners regarding the fact that there is no such special training course available in the state of Odisha in any of the institutions, MCI regulations for the purpose, and that of furthermore, OMS EF rules 2009 or the bylaw of the opposite party number 2 did not prescribe any such provision for assistant professor is also no way helpful to the petitioners because the assistant professors in the super specialty of medical and surgical oncology is indispensably required to teach and guide students pursuing PG and doctoral training as provided in the Rule 3 of the HRCC rules and bylaws, and not to merely accommodate the petitioner. Para 27, the assistant professor in the super specialty of the medical and the surgical oncology is indispensably required.
I think it's a repetition anyway.
This relates to that clause 3A of the advertisement, which relates to super specialization. I fall in the second category where they say this relates to that MCH, the super specialization. I will show in this compilation also, I have completed this 3 years teaching experience in senior residency, where the job of the senior resident is to teach the MCH students. This super I have I have annexed it.
No, my lord.
Let me complete
teaching experience.
Let me complete.
That doesn't mean that they are teaching the.
I will show that.
No.
I'll show that.
No, 1 minute. We were on the question where do you get 2 years special training in surgical oncology? Where does one get that?
That is only available if you do that senior residency. My lord senior can say something else.
No,
if it is there.
Had it been so, there would have been a floodgate of candidates at the time.
No, but tell us where does one get training? Where do you get this training? 2 years special training?
Tata Memorial Hospital, Sanjay Gandhi Hospital. There are many institutions providing those 3 years, 2 years, 1 year training, special training.
Those are the fellowship programs not recognized by MCA.
The fellowship program is also training, special training.
I have annexed the what are.
Moreover, I just want to point out before your lordship one thing. MCI guideline is to be followed.
That is what my case is.
Yes, ma'am. MCI guideline followed, but that is not binding. In
how?
In the context of while following the MCI guideline, and that too, government of Odisha, there are also rules. The advertise has been made, and there is nothing in the advertisement which is anyway in contradiction with those MCI guidelines, or now which is NMC. So now the question is the advertisement that is Annex 1 to the writ petition doesn't admit any such of alternative interpretations. The clear that broad specialty surgery subject, that is PG in broad specialty in surgery, plus 3 years resident, senior resident, plus 2 years training. He has got no such. He applied for that, quite knowing.
Draw my lord's attention to the compilation I gave. I just have few documents to show, my lord. Page 7. May I draw my lord's attention to page 7 of that compilation?
Yeah, that compilation was not even produced before the.
Let me complete here.
Honorable.
Page 7.
Another writ petition.
Page 7, my lord. This relates to Tata Memorial, my lord. Advertisement, same advertisement. Where, my lord?
Page 7 of?
My lord. Just compilation I gave. My lord. Page 7, my lord. That first one, assistant professor surgical oncology. This is Strata Memorial Center, which my senior was offering, the institute, my lord. In there, my lord, may kindly have a glance. MCH, that requirement, qualification, MCH surgical oncology, or equivalent, or MS general surgery, or equivalent postgraduate degree recognized by MCI with 3 years post-MS experience in surgical oncology, which I have. I got a call letter, the next page, my lord. I could not succeed, but I got a call letter for the same post.
No, that's true. Actually, that begs the question.
My lord.
So each institution
my lord,
prescribes a certain set of qualifications.
My lord.
There is no compulsion that every institution
my lord,
should publish identical set of qualifications.
Now what they say,
maybe Tata Memorial did not insist on practical training.
My lord.
Whereas Acharya Harihar has insisted on practical training.
My lord, that training, they say that it will be, this selection process will be conducted as per OMS rules and as per MCI guideline. MCI and nothing other than that. They have copied it from there. They cannot just make rules because they are under MCI. They will be guided by MCI.
No, guided by MCI is one thing, and copy pasting what MCI requires is another.
My lord, another thing is
that is not your case. That is
what they say that. What they say that 2 years special training. My lord, as per my case, I did need it. In addition to that, in that compilation, my lord would find I did
as per the advertisement, you do need it, sir.
No, my lord, may kindly. I have completed this 3 years senior resident in the same institute.
That is anyway required by the advertisement.
My lord. In addition to that, my lord, may kindly have a glance at page 32. I am continuing in the same department since 9/3/2019 till date. And I'm continuing in the same department. I'm working once after completion of the
deputation. My lord, he is a state government servant after deputation. Any doctor could have come. That doesn't mean that will give some mileage to him. That he has acquired such.
He is working in the same department.
A substitute to special training.
My lord, after completion of the senior residency, my lord, a person becomes eligible for assistant professor, my lord. In addition, after completion of the senior residence, if he is allowed to work in the same institute, in the same organization, my lord, more or less, if he is not given the post of assistant professor, but he is working as an assistant professor, or whatever it may be, he is getting the experience there. Special training. As per my knowledge, there is no special training in Odisha. What I have given, even there is no special training prescribed by MCI in any institute, my lord. There are few fellowship cases which my lord senior is saying. In addition to that, I have been working since 9/3/2019 till date in the same department, working above something more than the senior resident. This can also be taken as a special training.
You can't say the point is advertisement requires a certain fulfillment of a certain qualification. How does one add to it or subtract from it?
But that qualification, there should be some nexus between the requirement they have given. There is no too special. Special training is not available, my lord.
My lord, pardon, my lord.
Let them show where it is available.
He could have challenged that advertisement threshold.
According to
Instead
me,
of participating pursuant to the advertisement, he could have challenged it.
Living
so, there would have been the zone of consideration would have been much wider.
But this was the impression. This thing has been copied down.
Senior resident would have applied.
This has been. This was my impression. This has been from the MCI guideline and leaving apart some strokes and commas. But that made this difference because from the beginning of my case, I have said that I don't need this special training because I have.
But for you to say that, sir,
my lord.
It's not for you to say that. We'll have to give meaning to everything,
my lord. This additional. There should be, according to me, my lord, what they asked. I have that, my lord. And had that been a case, they would have come up with people.
All right. The challenge in the present appeal is to an order dated judgment dated, 31st May 2022 of the learned single judge dismissing the appellate's writ petition civil 27613 of 2021, in which he had challenged his non-selection as assistant professor in the surgical oncology department of the Acharya Harihar Postgraduate Institute of Cancer, Cuttack. bracket respondent number 1. Sorry, respondent number 2. Paragraph. In terms of the advertisement issued by respondent number 2 on 3rd February 2021, inviting applications for the said post, the prescribed educational qualification in the Department of Surgical Oncology, bracket, super specialty department, bracket, was that the candidate, open quotation, should have PG degree in super specialty, or the next line, PG degree in the concerned broad specialty, bracket, as per MCI, bracket, with 2 years special training in the concerned super specialty. Next line, the candidates were also expected to have 3 years experience as senior resident in the respective disciplines from any recognized medical institution recognized by MCI. Full stop. Paragraph. There is no dispute that the applicant did not possess a PG degree in the concerned super specialty, that is surgical oncology. Full stop. However, he did possess the PG degree in the broad specialty, which was single quote surgery. Full stop. In other words, he had a PG degree in MS bracket surgery. Full stop. It is also not in dispute that the appellant had 3 years experience as senior resident in the Department of Surgical Oncology in the respondent number 2 institute itself. Full stop. Paragraph. The only portion of the above qualification that the appellant did not possess was, open quotation, 2 years special training in the concerned super specialty, unquote. The case of the appellant was that he was not required in terms of the MCI regulations, which were applicable at the relevant point in time, that is MCI regulations amended up to 8 June 2017, bracket, to possess the above practical training, special training requirement. Full stop. Counsel for the appellant has drawn attention to the qualification as per the MCI regulations, where such requirement of special training in surgical oncology will be insisted upon only for those possessing MS in ENT or MS in orthopedics or MD in obstetrics and gynecology, bracket, full stop. Paragraph. It has been contended by learned counsel appearing for respondent number 2 that having participated in the selection without questioning the above requirement in the advertisement, the appellant cannot be heard to question the above requirement after the selection is over and he was unsuccessful. Full stop. Paragraph. There is merit in the contention of respondent number 2, as it is settled law that after participating in a selection, an unsuccessful candidate cannot challenge the conditionalities of such selection. Then
pardon, I didn't challenge it. I said that I already have that requirement. That's what my case was.
Yeah. Paragraph. In response, counsel for the appellant seeks to contend that he already fulfills all the requirements, and that it is not practical to expect him to have 2 years special training in the concerned super specialty, since there is no institute in the country which offers such special training. Full stop. This is contested by counsel for respondent number 2, who points out that such special training is available in some leading cancer institutes in the country. Paragraph. This court would not like to, in fact, inquire whether in fact such special training is available or not. Full stop. The fact remains that it is a requirement in the advertisement, and the appellant does not possess that particular does not fulfill that particular requirement. Full stop. Consequently, the court is unable to find any error having been committed by the single judge. The writ appeal is accordingly dismissed.
Item number 83. May
Yes.
May I please?
Yes.
Page 89 is the impugned order.
Pardon, my lord. On behalf of Mr. Das, my lord, yesterday I have received some intervention application. So kindly time to file a reply, my lord.
We have not even issued notice in that.
I have intervened for other purposes. The judgment, the very circular which has been passed, that should not have been made applicable to. So far, the judgment of the Honorable Single Judge cannot be made applicable to us because we are in a different category altogether. So far, the petitioner's case, people, he let him.
What has happened in this case?
I think last time Mr. Das was to give you a list of matters where it's been implemented.
My lord, he has given a copy just now. He has handed over a copy of that order of this Honorable Court in a different case that he is saying that has been implemented. But the copy of the judgment has been given to me just now.
All right. You say Mr. Kuntia states that Mr. Das has only just now handed over a list of matters.
Only one judgment
where the order of the single judge has been implemented.
No, but that has not been implemented. What he has given that judgment has been passed in compliance to this order of this Honorable Court, Honorable Single.
Yes, I was also party to that. Lord. That is a different thing. Now let him submit.
On last occasion, while I was pointing out, my lords, that entire notification has been passed. Though that lords may see that notification is page 35.
Yes.
There are 7 category of persons that dispute relates to 5 categories. But the entire notification was passed. On last occasion, Mr. Das said, in respect of other categories, that has been disposed of also. So he has given a judgment that is also does not relate to category A and B. That relates to that within that 5 categories that where date of birth has been confined. That on last occasion, I have also submitted that so far as date of birth is concerned, I don't have a case. But this divides 2 categories of persons. A to G. C to G, they stand on date of birth, and A, B stand on different footing.
A, B are the reader. In the rank of reader, they have been given. A, B, we are under that category. That is not a dispute before the Honorable Single Judge.
So, if you will call this matter tomorrow, I can say that whether this judgment is.
See, that judgment, that's a different, that is also confined to that. You also look to the impugned judgment.
I am on the only category of A and B.
Yes.
Not in others, because that date of birth.
Your Lordship may say, so far the judgment of the Honorable Single Judge, so far category C to F, admittedly, my lord. So far A and B is concerned, that will not happen because that was not the case at all. You also look to that.
7 categories are there.
7 categories are there.
I am considering, but in 5 categories, date of birth has been treated as.
No, Mr. Das's clients come in which category?
That is C.
So if you can clarify that it doesn't apply to A and B, it doesn't hurt him also.
That's right, sir.
Only to
that's
that
right.
effect, A. It is not applicable to
A and B. That's right.
That is applicable to respect of all other categories.
Sir, block grant schools, block grant colleges are applicable. We are all under direct payment colleges, and we are the reader, and we have given also in the UGC scale.
The case of both the Mr. Samir Das, learned counsel appearing for the respondents, as well as the interveners in IA number
3124 of 2020.
Interveners are different.
3124 of
2022. We belong to A and B.
So today also I have filed for 3 persons, my lord. I am intervening for 3 persons. Those who are getting the UGC scale up.
Yes, we are also same category.
And certain other interveners, that they are all covered in categories C to F.
No, sir. The interveners, they are covered on category A and B. Petitioners, those are petition before the single judge. They are category C to F.
All right. Then you are what, sir?
Category A and B. We are category A. I am category A.
I am also a category A.
That was not the subject matter of dispute.
The case of those appearing for the case of the respondents in the present appeal. Respondents 1 and 3, is it?
Yes. Respondent 1 and 3, yes. Kamalakanta Das and Sarita Mall.
Sarita Malla was the opposite partner there. Before Honorable Single Judge. Mr. Das was repenting
Kamalakanta Das, yes.
The case of the writ petitioner, that is respondent number 1 in the present appeal, is that being a lecturer in a institution that receives block grants, is it?
Yes,
block grant.
Yes.
That receives block grants. She's not covered in categories A and B of the advertisement issued.
No, that is the circular.
Notification.
That
That is the guideline.
That is the guideline.
Page 35, my lord, you also can find it.
Better you also look to page 35.
Guideline issued by the Director of Higher Education.
No, Government of Orissa Higher Education Department.
Right, by the Higher Education Department of the Government of Orissa.
On 31/8/2020.
On 31/8/2020. Full stop. That guideline is regarding fixation of seniority of teachers in non-government aided colleges for the purposes of appointment of principals and HODs.
Principal in charge.
Yes. Full stop. Category A and category B read as under. Then reproduce category A of bottom of page 35 and top of page 36, category B.
Yes.
So in other words, the writ petitioners before the learned single judge were not concerned with categories A and B at all.
Yes, sir.
Paragraph. On the other hand, the interveners in the present writ appeal belong to those categories.
Yes.
Full stop. Therefore, the concern of both the appellant before the court as well as the interveners is that the impugned judgment of the learned single judge dated 11 July 2022 should be confined to categories C to G.
C to F. G to H. C to F.
C to F.
C to F. C to F.
No.
And will not cover categories A and B.
Yes. And also G. G also selection board candidates. G.
Yeah. And will not cover
A,
categories
B, and
A,
G.
B, and G.
Yes.
Full stop. Paragraph. Considering that the challenge in writ petition civil 2T of 2022 before the learned single judge was by persons not belonging to the above categories, that is A, B, and G, it is obvious that the impugned judgment of the learned single judge will not apply to those categories.
Yes, ma'am.
Yes.
Full stop. With this clarification, the writ appeal and the intervention applications are disposed of.
Obliged.
All right.
I have filed a writ appeal with a leave of the court that will also can dispose of in view of this order. This is also disposed of. Second one. This sub-item W812.
In view of the order passed today in WA 1020 of 2022, this writ appeal is also the same terms. All right.
Obliged.
Obliged.
Right.
Item number 84.
84, my lord. Today we have received the counter from OP number 1 during the lunch hour, my lord. So we require some time to respond to that one.
All right, rejoin to be filed before the next date. What's the matter about? Now, what about the disbursal of compensation that's done?
Lordship.
No, the disbursal of compensation, has it happened? Mr. Monty?
Yes, my lord. Lordship may kindly
February
have a glance, page
2022, compensation to the victim should be disbursed.
Page 5 of the counter affidavit.
Where's the counter? It's not marked here.
Same was sent to the government in SSD department by so and so for dispersal of monetary relief amount directly to the account of beneficiary, as government in SSD is the distributing authority. The case has been settled in the meantime and amount of rupees 1.5 lakh has been transferred to the account of the beneficiary, namely Kausalya Bhara, exhibit C by 1. And the beneficiary has submitted a receipt showing the exhibit D by 1.
So counter is not received yet.
It was filed by 26th September, day before yesterday.
So this compensation amount has been received, sir.
What has happened in this case, Miller Lordship, kindly remember, on behalf of Mr. Pulka, Miller Senior Counsel, he was appearing in the case, Miller. Today he is having some personal.
No difficulty. No, the amount he says has been disbursed.
What happened is the amount, there is a difference, Miller. This SCST commission, the victim compensation, that is under challenge, Miller. This is not under the compensation they have given. That is why Mr. Pulka was on last occasion also arguing that the victim compensation is...
All right, the counter affidavit of the state be placed on record, rejoined to be filed before the next date. List on 14 December.
Oblige.
Item number 85.
I mean, BC, my lord, the petitioner before my lord are the president or secretary of the Citizens Forum Union. In this case, what happened, your lordship must have remembered that disconnection of power supply to the where 13 panchayats have been disconnected regularly 6 p.m. to 6 a.m. morning. And so far the counter filed by the opposite party 7 and 9 are concerned. Your lordship may kindly glance the para 9 of the counter, my lord. Page 4 counter, para page 9. And the representation are pending before the collector. Only I pray, my lord, your lordship may kindly dispose of directing the collector to take a decision.
My lord, may I pray, my lord? My lord, this Honorable Court also directed on to 27/4/2022, based on the allegation that there is a rampant power cut from 6 p.m. to 6 a.m. That is not the fact. Your lordship called for the records, and that has been filed by me. Respondent number 7 and 9 for in form of additional affidavit. And thereafter, my non senior friend accepted that there is no power cut at present. It was earlier. That was the version he submitted before lordship. So, in view of that, Millard, and in view of the prayer, Millard, to follow, your lordship may kindly see the prayer only. Prayer is to implement the direction as per annexure 1 and 2. Now, I have submitted that it has been implemented according to the letter and spirit. So, let your lordship nothing remained, Millard. Nothing remained, Millard.
Each and every day now also they are disconnected.
Now, how can you say you have not filed any rejoinder or disputing my affidavit till date in spite of this honorable court's direction and
for that
time
reason,
given?
My lord may kindly dispose of the
application. Prayer has already meted out. There is no dispute over that. That is the government guideline, and we have to follow it. Accordingly, we are being followed. So, in view of that prayer which has already been meted out, your lordship may dispose of. Nothing left to be decided.
You see, a counter affidavit was filed by the executive in TPNODL, Kionshar.
Additional affidavit. So, also additional affidavit.
7 or 9.
Pointing out inter alia that any disconnection or reconnection of power supply happens only strictly in terms of the instructions issued
Annexure 1 and 2
by the Energy Department, Government of Odisha and NESCO utility. And that too only in the elephant corridor and in movement areas of elephant/wildlife. Stop. It is stated that there is no routine disconnection of power supply from 6 p.m. to 6 a.m. in the areas in question as alleged by the petitioners. Paragraph, a separate affidavit has been filed. An additional affidavit has been filed by the same executive engineer, TPNODL, on 8 May 2022. Placing on record the extracts from the logbooks for the months of March and April 2022. And full stop. The counsel for appearing on behalf of opposite parties 7 and 9 assures the court that there is no routine disconnection of power supply any longer. Full stop. There is no rejoinder filed to counter the above contentions. Full stop. A separate affidavit has been filed by the Assistant Conservator of Forests, bracket opposite party number 8. Stating that TPNODL has never been asked to disconnect electricity supply in the Telkoi area during the daytime. Stop. As far as instructions for disconnection of power supply in a particular area, it is only in the when the transmission line is passing through the reserve forest, elephant movement areas, and close to the forest areas, and that too only for a limited duration. Full stop. It specifically denied that any instruction was issued to TPNODL to disconnect power supply in Telco area between 6 p.m. and 6 a.m. Full stop. Paragraph, even you say no count, rejoined affidavit has been filed to any of the above affidavits. Also, it appears that the situation is now well within control, with there being no particular grievance remaining of the petitioners. In that view of the matter, no further directions are called for. The petition is disposed of.
Item 86.
Dear Lord. 86, my lord, I have filed a rejoinder today to the counter affidavit filed by the state, and I have served copies on the state, but I have not served copies on the counsels appearing for the other parties. You may call it therefore after vacation, my lord, so that I will serve copies.
The rejoinder has been filed today by counsel for the petitioner. Copy thereof be served on counsel appearing for opposite parties 6 to 8. List on 15 December.
Can it be earlier?
All right, 23rd November. All right.
Pastor. Supplementary list, pastor matter, item number 5.
I am for the opposite party, my lord.
None appears dismissal now.
Supplementary list, pastor matter, item number 21.
May I please, your lordship? My lord, the appellant has filed the apportioned rate appeal not passed by on 1/12/2015, passed in a WPC number 11241 of 2013, wherein the learned single judge, while refusing to interpret the order passed by the ADM Hindor. Notice was issued. The opposite party government has filed the counter, and opposite party number 4 has not filed any counter. What has happened, my lord? One advertisement is issued on 13/10/2009 by the CDPO, Child Authority, under Annexure 1 to fill up the post of Anganwadi worker in different Anganwadi center, including Khandotiri 4 Anganwadi center. Pursuant to the advertisement, the appellant was applied for the post of the Anganwadi worker. She was selected on 18/1/2010. When she was continuing, the opposite party number 4, after 2 years, on 15/11/2012, filed an appeal before ADM, challenging my appointment order issued by the CDPO. The appellate authority, without considering the question of limitation, had the matter and passed the order on 6/5/2013 in favor of the respondent number 4. She is secured the highest mark and she should be engaged against the post of the Anganwadi worker. My respectful submission, my lord, petitioner was a retrenched early child care instructor, education instructor for engagement as Anganwadi worker. My lord, kindly see page annexure 4, running page 23. My lord, got it?
Yes.
In course of the time of the opening of Anganwadi centers, the retrenched ECCE instructor would be engaged as an Anganwadi worker. This is the meeting for the proceeding. The meeting held on 22/12/2008 under the chairmanship of the Honorable Minister of Finance regarding problems of the ECC instructors. My lord, I was selected. She prepared an appeal after 2 years.
She will write this order.
My lord, kindly see running page 6, my lord. Para 9, that it is pertinent to mention here that the appellate authority did not properly appreciate the question of limitation and came to a erroneous conclusion that since no limitation has been prescribed for filling up an appeal, the appeal filed by the respondent number 4 is not time barred. In this context, it is humbly submitted that where no limitation has been prescribed, certainly the provision of the certainly law will be made applicable. Besides that, the appellate authority has also not considered the fact the post of Anganwadi worker is a class 4 post. In a class 4 post, selection is ordinarily made on the basis of the suitability cum merit. Since the appellant was found more as she has got experience as ECC worker, she was found more suitable of the selection committee. When a guideline does not prescribe any limitation, in such case, the general law, the Indian Limitation Act, is applicable in view of the provision of the General Clauses Act. Therefore, in view of the provision contained in the Indian Limitation Act, 1 month time has been provided to file an appeal the appellate authority for challenging the selection. Since the appeal was prepared after a long lapse of 2 years, the same was hopelessly barred by limitation. This is my first submission, my lord. My lord, kindly see, I have taken 2 grounds, my lord. One is barred by limitation. After 2 years, when I was continuing...
Don't again repeat, sir. The only thing you've been talking so far is limitation. Don't repeat it
Yes,
now.
my lord.
What was the second contention?
My lord, second contention is, I am not misrepresented or misled any of the authorities to get engagement as an Anganwadi.
What do you say to the fact that she got more marks than you? What do you have to say for that? You have nothing to say.
My lord, actually, I was a retrenched ECC. As per the proceeding, those are retrenched ECC, they are given preference and they are selected to the Anganwadi worker, my lord.
Anyway,
I am for the respondent number 4 million.
It's all right. We're not interfering. We'll pass the detailed order. There's no merit in the present appeal. It's dismissed. This interim order is vacated. All right.
The petition
Item
number
of
of the respondent number 4 is the
36.
continuing.
Item 36.
Publish, my lord. Samudra dismiss.
May it please the Court. This is also a matter relating to the appointment of Anganwadi worker. Pursuant to an advertisement, several candidates have applied, including me and the opposite party number 6. I have raised an objection saying that the opposite party number 6 does not belong to the where this Anganwadi center is. Then there was an inquiry set up. In the inquiry, a report came that she doesn't belong to that area. Opposite part number 6 doesn't belong to that area. Thereafter, in the writ petition, that inquiry report was considered, but then state government has filed a counter, filed an additional affidavit stating that although the opposite part number 6 doesn't belong to that area, she has been taking benefits in the Anganwadi center, and therefore your lordships have English translation. The report reads like this, at page 64. But that's in Oriya. I'm giving the English translation. Detail of this. It's a translation. Page 64. As per the objection raised by Srimati Mamata Pradhan, wife of Rabindra Kumar Patra of Bandolo, it is hereby revealed from the local inquiry that Smita Behera, this is opposite part number 6, wife of Ramesh Chandra Behera, and Narmada Sahu, wife of Pabitra Kumar Sahu, are residents of Tolasahi of village Bandolo, but the pregnant women and preschool children are getting all benefits and government help from Bandolo 3 Anganwadi Center. So that she doesn't belong to this area was stated. That's not right. In the report, in Odia, it is very clearly stated. I'm sorry, this translation is not up to this. Abhijog Karani, Srimati Mamata Pradhan, so Rabindra Kumar Patra, so and so Bandalo Abhijog Kurthiba, Abhijogro Tadantaka Stani Tadanto, Odanto Janagolaje, Smita Behera Swami, so and so, of Narmada Sahu, Swami so and so, Bandalo Tahsilro Adivasi Otanti. Kintu so they belong to another service area and not belonging to this area, but they are taking base from the government help from this area. That is the additional affidavit filed by the government. Honorable Single Judge took note of this and Annexure 16 at page 71, you will also get it. The relevant portion begins after the entire history, the relevant portion begins at page 74. Second line. The petitioner, along with 6 other candidates, including the private opposite party, applied for the post in terms of advertisement dated so-and-so, and all were called on for verification of original documents. The petitioner has challenged the candidature of opposite party number 6 and one Narmada Behra on the ground that both of them are not residing in the central area. The said objection was accepted by the Child Development Project Officer, but without considering the objection, final merit list was published on 19/6/15, and the opposite party number 6 was selected as Anganwadi worker for the center in question. The petitioner has obtained relevant documents under the provisions of RTA Act, and said documents substantiate that the opposite party number 6 does not belong to the service area of the center. This Honorable Single Judge takes note of. And thereafter, in the next page, you will also find the opposite party state as well as opposite party number 6 have appeared and filed their respective counter affidavits. Both of them have submitted that the petitioner as well as opposite party number 6 are residing in the service area where the center is situated. Submitted that the inquiry report as annexed in page 63 also suggests that opposite party number 6 is residing in the area where the center is situated. This is factually incorrect. So far as the additional affidavit is concerned, that runs contrary to the report itself. And based on that, then the next page, my lord, same page, last lines, held and counsel for the parties and perused the documents on record. The undisputed fact that in this case is that petitioner as well as opposite party number 6 have participated in the selection process. The petitioner has objected the selection of opposite party number 6 on the ground that opposite party number 6 is not a resident of the area where the center is situated. The advertisement has been issued for appointment of Anganwadi workers for Bandalo 3 Anganwadi Center, which consists of Padisai, Patrasai, and Bhandarisai. The petitioner as well as opposite party number 6 reside in Bandalo in the lower side of the village. The assertion that which has been made by the opposite party state that there is no area in the Bandalo village known as Tolasai, and the reasoning given in the additional affidavit as required by this court by order dated 8/10/15 is accepted due to the fact that Tolasai or Upparsai is the location of the area. Upparsai means upper portion of the village, merely because the joint inquiry report at page 63 of the writ petition shows that opposite party number 6 is residing in Bandalo Tolasai. It cannot be said that Bandalo and Tolasai are two different villages. Rather, it is the lower part of the Bandalo village. Hence, the argument advanced by the counsel for petition, relying on joint inquiry report, has not been taken into consideration. Therefore, my humble submission before your lordships is, once the inquiry on facts and inquiry report was submitted, and an inquiry report says that the opposite number doesn't belong to Bandalo, that is the service area, based on an additional affidavit filed by the state in the before the honorable court, stating that they belong to that, which runs contrary to that advertisement and also contrary to the report itself. The single judge should not have accepted that additional report. And
you're not inclined to interfere. You said the writ appeal is directed against an order dated 14 December 2015 passed by the learned single judge, dismissing the appellant's writ 67 of 2015, whereby the appellant had questioned an order dated 2nd December 2012 passed by the additional district magistrate Cuttack, dismissing the appellant's Anganwadi appeal number 4 of 2014. Paragraph. The background facts are that advertisement was issued on 20th February 2009, inviting applications for engagement of Anganwadi workers, bracket AWWs, for the Bandalo 3 Anganwadi Center, bracket AWC, which consists of 3 Sahi, namely Padi Sahi, Patra Sahi, and Bhandari Sahi. Paragraph. The appellant was not selected, but one Mamatalata Tarai was selected and given appointment. Full stop. After she resigned, the post fell vacant. Another advertisement was issued on 26th June 2013, in which again the AWC area was described identically. Full stop. And short of the narration is that private opposite party, that is respondent number 6, got selected. Full stop. Her selection was challenged by the present appellant on the ground that she was not a resident in the area in which the AWC was situated. She was shown to be residing in single quotes Bandalo Talasai. Paragraph. Before the learned single judge, an affidavit was filed by the state government explaining that Tala Sahi or Upper Sahi is the location of the area. Full stop. The learned single judge took note of the fact that the joint inquiry report of the Tahsildar and the CDPO of the inquiry report of the CDPO revealed that respondent number 6 was a resident of Talasahi of village Bandalo. Full stop. However, the learned single judge noted that Talasahi and Bandalo were not two different villages, but in fact was lower part of the Bandalo village. Paragraph. Having heard learned counsel for the appellant, the court is not persuaded to take a different view in the matter. So the concurrent findings of both the ADM and the learned single judge on facts is against the present appellant and in favor of respondent number 6. Consequently, the court finds no reason to interfere. The appeal is dismissed.
Item 55.
May I try, my lord, this petitioner is suffering from the Duchenne muscular dystrophy, and by order dated 16/9/2022, your lordship have sent that 15 children to AIMS. I have annexed that order at page 41. This same order can be passed, my lord, in favor of the petition.
This is one more petition by a person suffering from Duchenne's muscular dystrophy, bracket DMT, in respect of which this court has passed a detailed order on, which is item number 55.
Item 55, madam. And the case is posted to 11th of October, madam.
16/9/2022. Full stop. List along with writ petition civil PIL number 14289 of 2022 on 15th October.
11th October.
11th October 2022. In the meanwhile, Counsel for the Union of India will obtain instructions specific to the present.
And some treatment now we are providing some treatment to the children.
All right. You better extend it to the present petitioner also. Ah.
May I, my lord? Pardon, my lord.
Item 5 just missed the boat, Miller. Item 5 pass over. I just missed the boat, Miller. If a let's see, please, then any other time, Miller, I will assist.
What's the matter? What?
My lord, in this matter, the improved order at page 13 and 14, Miller. And I am aggrieved by the observation made at para 6 and 7. The fact of the case is that, Miller, the present petitioner or the present appellant, he was a resident of Bihar. And in Bihar, issued a caste certificate certifying him that he belongs to SC Milot, Pano. And thereafter he migrated to Odisha. And in Odisha, that Pano caste is also notified to be a scheduled caste Milot. In Odisha, in Kendusar district, he purchased a landed property himself, and his wife purchased 2 landed properties Milot. And after 10 years after that purchase, the son of the vendor, he invoked section 22 of the Oiler Act and alleged that without taking permission from the competent authority, the sale transaction is made, and basing upon that allegation, my sale deeds are cancelled, my lord. I challenged it for the Honorable Court, for the Honorable Single Judge. And the Honorable Single Judge at para 6 of the impugned judgment hold that when he migrated from Bihar to Odisha, obviously he lost his status as SC. But my lord, he became oblivious to Annexure 8, that is the caste certificate issued to me in Odisha as SC, as Pano. And in Odisha, Pano is also recognized as a SC.
No, what has happened?
My lord, my 2 sale deeds are cancelled, my lord, by the sub collector.
There's no stay granted in this court, sir. Has there been any stay granted?
Yes, my lord, stay was separate. My lord, the brief was given to me last night. That's why I was mentioning.
There is clear, the order passed on 7 November 2016,
my lord,
stating it is made clear that there is no interim order passed in this case.
My lord,
no interim order has been passed.
If your lordship post this matter any other day, I may assist your lordship in a proper way, my lord. Because, my lord, this brief is transferred to me last night.
So we're not.
And at least I cannot do justice to the brief, my lord, at least. That's why I humbly pray, my lord, any other day, my lord.
Why don't you apply for restoration, sir? Then you'll be better prepared. We'll restore it and hear you on that day.
Then I will.
All right.
I will file restoration.
May I, my lord?
Yeah, sure. These are those, they're in jail. This 90 is 2022 matters. What is urgent about it? Why don't you call out?
Pardon, my lord, item 30. Pardon, my lord, item 38, I missed it, my lord. I was engaged in another court, my lord.
You apply, sir. Can have it restored.
87 is hearing. Criminal appeal.
What is the matter about item 38?
Criminal appeal.
1 minute, sir.
Criminal appeal.
1 minute, sir. Kindly wait.
My lord.
What is item 38?
Item 38, my lord, it set aside the impugned dated 17/3/2013 passed by the Honorable Single Judge in WPC 16-125/2011 in Annexure 18, page 66, my lord. I'm reading out the judgment, my lord. Considering the contentions raised by the learned counsel for the opposite parties, the result has been published, and pursuant to selection list, the selection person have been joined in the posts. The writ petition cannot sustain at the instance of the petitioner. Therefore, with the efflux of time, the writ petition has become infructuous and kindly disposed of. My lord, we have already sent a letter for up-to-date instruction from the petitioner. This can kindly come up on another date.
No. If you have no instruction, you have no instruction, sir. Counsel for the appellant states that despite writing to the appellant, they have no instructions. Dismissed for non-prosecution. All right. Yes.
7 is for hearing. 302 case.
No, the appellant is in jail or he's out?
He's in jail. He's in jail.
You're ready with the matter, sir?
I am ready, but today it is not possible, my lord.
Tomorrow?
Not tomorrow, my lord, because I have already.
You have already?
Tomorrow I have already been engaged elsewhere.
Counselor present, but he was present before just 2 minutes before.
All right, well.
Item 89.
Lord. Yes. See, in criminal appeal number 331 of 2018, she is in custody over 10.5 years.
2016.
Yes. This is she is in custody over 10.5 years.
So Reddy will hear tomorrow.
Yes, my lord. That court has no jurisdiction. That is the first point. Court which has decided the
All right,
matter.
tomorrow we'll hear tomorrow.
Yes. Yes.
Another item is also connected matter, madam.
Correct. So we'll hear tomorrow, sir.
I have received the paper book on maybe any other day.
Tomorrow, sir. We get ready in 2 hours. For you, you are a seasoned lawyer, sir. You're much more seasoned than all of us.
No,
For you, it will take not even 1 hour.
On the day of reopening.
Then you also sit down and listen to Mr. Jena is fully ready. Same matter.
No, certainly not. Well, I have my own case. So, present appellant is concerned, he has absolutely no matters there. But that is there, not only after the reopening, madam.
No, sir. It's difficult. Everything can't be after reopening. For us, it is difficult, sir. Tomorrow we'll take it up. All right.
Item 90.
Please, my lord. I'm on VC, my lords.
What's the urgency here?
My lords, there's no such urgency, my lords.
All right.
I pray it may be taken up after vacation, my lords.
No, why? If there's no urgency, it will come up in due course.
Obliged.
All right. Is it admitted or not?
It's admitted, my lords.
Yes, ma'am. March 2022, it says that. 28th March.
Paper books are ready.
Yes, my lords.
Include in the list of final hearing matters in the regular course. Right. All right.